Wait, till-
Yes.
myself item number 7. So I'll collect the paper book, and in the meanwhile, my lord, let the next date be fixed after vacation, my lord.
7.
7.
Hmm.
I am as a amicus curiae, my lord.
Okay. Then we'll give time. Mr. T. Son, Learned Legal Aid Counsel. For the appellant is present. The trial court record is still awaited. In view of the above, list is matter after 3 weeks. The list is matter after receipt of the trial court record.
Obliged.
Item number 1.
Your Lordship, I'm appearing on behalf of J. Jenny. On the last occasion, this TCR was called in connection with the criminal appeal number 5, 2018.
Yeah, that is, yes. Lordship,
Okay.
TCR yet to receive, Lordship.
Hmm?
TCR yet to receive.
Yet to receive.
Yes, Lordship.
It's received, it appears.
Cumulative jail is mostly connected with 7 TCS there.
TCR, yeah.
Cumulative 5 TCS.
Bill 5.
7.
The same case. Probably copy, scan copy. Okay. Mr. Will,
Okay, good.
it appears the
Mm.
mail is sent here. They have filed probably recently, I think. Mail case sent there. Full code.
Yes.
Scan copy receipt. Full pass. Okay. Mr. Nega is?
I'm appearing on behalf of J. Jenny, his amicus curiae.
Okay, Mr. T. Nega, Learned Counsel appear on behalf of Mr. J. Genie, amicus curiae, for the appellant, staff, Miss L. Hage, Learned Additional PP, and Miss Inti Zira, Learned Legal Aid Counsel for the Legal Aid Counsel for the respondent number 2 are also present. The scanned copy of the trial court record has been received. Staff, the registry shall prepare paperwork based on the scanned copy of the trial court record and place the matter after serving the copy to the Learned Counsel appearing on behalf of the parties. Okay?
Obliged.
Right, Lordship. Item number 2.
My lord, this case is relating to enhancement of salary of the casual staff on the basis of equal pay for equal work. My lord, the petitioners, they are working as casual laborers in the department of PHE. They are working as fitter, carpenter, driver, revenue attendant, mali, computer operator in different posts. And the person who are working the same nature of work, they are given better salary. My lord, this writ petition was filed on the basis of 2 judgments of the Supreme Court. That is Uma Devi's case and Jagjit Singh case. In these 2 cases, Supreme Court has passed judgment that the persons who are working similar nature of work are entitled to get same salary, my lord. And in this case, the learned single judge has passed order not granting the relief that was claimed by me. And being agreed by that, this appeal was prepared.
Mhm.
No, what is wrong in that?
My lord,
What is wrong in single
Uh,
judge's opinion or?
in the single
what-
judge, before the single judge, I was claiming that I'm entitled to get salary equal to the lowest cadre of the, equal to the regular employee of lowest cadre of the same post. As per Supreme Court judgment, my lord. And without granting that relief, the learned single judge has granted some other relief, which is not claimed by me. It states in the operative part, page number 104, para 19. For the foregoing reasons, this court is of the considered view.
You read 18 also.
Yes, my lord. In the present case, having considered the matters in its entirety, it is noticed that the petitioners are provided with the monthly wages akin to the minimum pay scale provided to the regular employees holding the same post and in fact higher than the minimum pay scale. Thus, this court finds difficulty in granting relief for payment of minimum pay scale and other service benefits as claimed by the petitioners.
Yes, that has been hold.
My lord, there is a difference.
What is the difference?
Here, minimum scale is granted, my lord. Only scale, not the whole salary, entire salary. Means other service benefits were not granted. Only basic pay. But I am claiming equal to the salary of the regular employee of the same cadre, as per Uma Devi's case and Jagjit Singh's case. If these two cases, if my case is not covered by these two judgments of the Supreme Court, I have no case.
You are working as what?
Casual laborers means, my lord,
Casual labor.
my lord,
You were seeking parity with the regular employees.
yes, my lord, of
Regular-
lowest cadre.
Correct, lowest cadre.
Huh.
But like you were a contract employee, right?
No, my lord.
Then
I am casual staff, my
the
lord.
casual staff. Casual staff working is what basis? I mean,
My lord,
contractual. or
I am in
what?
different posts.
Hmm.
So many petitioners are there. Some are Peter, some are Chokidar,
Hmm.
some are peon, some are maid, some are mason, some are WI, work inspector, some are carpenter, some are driver, some are mazdoor, some are revenue collector, some are revenue attendant, some are mali, some are computer operator. Petitioners are working in different posts, my lord.
Subsequently, the wages of the unskilled skill has been enhanced during the pendency of the writ petition.
Yes, my lord.
Yes.
Yes, my lord.
And you are getting now around 18, 19, 20, 30,000, etc.
Yes.
And these has been considered.
Yes, my lord. But one thing, my lord, I did not sought for the relief that has been granted in this matter.
Yes. Yes.
If this is sale also, it may be admitted for hearing also.
Please, yes.
Okay, so what is the difference?
Okay. Mr. Koya, learned counsel for the appellant. Staff. by this appeal, by filing this appeal, appellant as well the judgment in order dated 11/6/2025 passed in WPC 590/2024, wherein the claim of the writ petitioner for payment of salary equal to the salary and allowances that are being paid to the regular employee of their cadre in government service has been declined to grant. Mr. Harper. Admit, the appeal is admitted. Issue notice. Since Mr. Lion Senior Government Advocate appeared and accepted notice on behalf of the respondents, all the respondents,
Close.
all the respondent, all the state respondents, no formal notice is required to be sent. However, the appellant shall furnish requisite extra copy to the Lion Council, the Lion Senior Government Advocate for the respondents during the course of the day's staff. Call for the record. Mr. Chair. Okay, list this matter after 4 weeks. Okay.
Obliged, my lord.
Item number 3.
Wait, Mr. Lordship.
Hmm.
My lord, basically, I'm standing here with a human face also. But anyway, my lord, initially, during the 2024 examination, I was caught with a mobile phone, but it is on records that I was not using it. Now, in that exam, I was debarred from further proceeding. Then later on, another examination came up, that is assistant engineer post. And in that assistant engineering recruitment process, I have applied, but I was debarred just before the examination. And since I was already debarred from the earlier examinations, and this second debarment, it was on the ground of double jeopardy, because rule says A and B, it is not N, it is OR. So on that ground, I have filed my writ petitions, and then that writ petition has been disposed of, holding that this does not amount to double jeopardy, and or because it is a public service examination, so a strict sense has to be taken, and therefore or has to be read as conjunctively with N. So on that ground, the learned single judge did not interfere, but the learned single judge found that the punishment of debarring for another 1 year is harsh and not proportionate, my lord. So on that basis, the learned single judge molded the prayer and then restricted the punishment up to the date of judgment, my lord. Now, my lord, my small prayer is, my lord, in the meantime, the hearing was concluded on 2/9/2025, and judgment was delivered on 4/12/2025. In this intervening period, another examination was advertised, that is for the junior engineer, my lord. Earlier one is the assistant engineer, the second is the junior engineer. Now, because of the delay in pronouncing the judgment, my lord, I am now not being able to appear in that exam also, the junior engineering examinations. The examination is slated on 11 January, my lord, next year, my lord. So, my lord, my reservable submission is, because of the delay in pronouncing the judgment, my lord, I am being victimized. My only prayer is that, my lord, it should be, the punishment should end from the day the hearing was concluded and not from the date of judgment. And if my prayer is allowed, well, I will be able to appear in the junior engineering examination, my lord. As a matter of precaution, the last date of submission was on 10/10. So I have filled my form, my lord.
10/10 what?
10/10. My lord, in paragraph 9, I have described it, my lord.
10/10/25.
Yes, my lord. On 17/9/2025, another advertisement was issued by the APPSC for the recruitment to the post of junior engineer, my lord. And the last date of submission was on 10/10/2025. I have filled up my on 5/5, my lord. 5/10. So, my lord,
When this judgment was passed, judgment and order was passed,
judgment was passed on 4/12/25, my lord, at page 18, my lord. Page 18. My lord, may I just take your lordship to paragraph 41 and 42 of the judgment?
Yes.
Yes.
Page 44, my lord. May I read, my lord?
yes,
Paragraph 41 and 42.
yes,
Having said that, it must also be kept in sight that the petitioner is the person with benchmark locomotor disability and is wheelchair bound. The petitioner is a young citizen of Eastern Arunachal Pradesh, and although she has fairly admitted in her reply that she did not possess the mobile phone during the period of examination, but there being no materials placed on the APPSC to show that not actually this it is an admitted fact that the mobile was found. But the APPSC to show that the petitioner had used mobile phones during the course of the examinations within the examination hall or even outside. Therefore, the court considers the imposition of punishment of debarment for a period of 1 year to be harsh. As held in paragraph 42, as held in Om Kumar Supra, that where the situation demands, the quantum of punishment can be suitably molded by the writ court, although it is primarily within the domain of the administrative authority, as the writ court is well empowered to decide on the question of quantum of punishment. While for the reasons discussed, this court rejects the contention on behalf of the writ petitioner. However, this court considers it appropriate to mold the relief to the extent that under the facts and circumstances of this case, the punishment undergone so far, in the opinion of the court, is considered be sufficient. The impugned order, to the extent it imposes debarment for a period of 1 year, is therefore modified to the extent of the period undergone by the petitioner till the date of delivery of this judgment. The impugned order of debarment of 1 year is accordingly suitably modified in terms of the above. The petitioner will now be able to appear for any examinations conducted by the APPSC subject to fulfillment of provisions of law, madam. Now, my lord, why I'm insisting is that, my lord, in the state of Arunachal Pradesh, especially in the electrical and mechanical department, the recruitment process, there is hardly any post. There is hardly any recruitment process, my lord. And in fact, this assistant engineer for the in the electrical department, it's coming after almost 8 years, and then junior engineer also is coming after almost 4 years, my lord. Now, my lord, since I have been debarred, my lord, I agree that from that assistant engineering examination, the exam also is over. Now it is the viva voce status has come. My lord, at least in this junior engineering examinations, my lord, if this molding the period, if it could be just restricted to the date of final hearing, my lord, then in that case, I will be able to appear in these examinations, my lord.
but the court has made clear that till the date of
Judgment is 4/12, my lord. In this manner, I will not be able to appear in the junior engineering examination, my lord.
And in spite of you're being caught, and that is the admitted fact. And court has given you the relief. I mean, what do you want more from this court?
My lord, at least
See, the court may take some time to write a judgment, that doesn't mean that you will get a right when during that period some advertisement has come. So when the matter was heard, that is not a kind of relief the court can give.
My lord, that is why, my lord, in the beginning only I submitted that basically with a human face. But at least she's a wheel-bound chair,
Yeah,
lady.
that's there.
Well,
that's
that at least on the human face, my lord, consideration that if it could be just protected, so that she can appear in this engineering examinations.
Whether review file for modification? No,
No, my lord. No.
can't. When the advertisement was issued?
17/9.
Okay, 17/9.
17/9.
The delivery is 4/12.
My lord, in the meantime, after this 17/9 advertisement, since the judgment was not forthcoming, I have filed a IA also, but then it was sent
I
to-
before her. But
before the landed single judge.
okay.
Before
in the present writ petition,
I have elected in my
that has been considered.
no, my lord.
what happened to that?
No hearing was took place, my lord.
When did you file the IA? You made a statement here.
Yes, my lord.
But which paragraph?
My lord, in my ground also point for ground for conclusion of the year, but at page 13 also I've taken. Point number F, my lord. IA nominal census could not be considered only due to the pendency of the judgment. This also demonstrated that the appellant was actively seeking permission to apply participation and denying that opportunity due to reserved judgment is unjust.
When the examination is due?
11 January 2026. And in my prayer also, I have in the interim, I have showed this prayer and in the IA also. my lord.
This is for what examination said?
Junior engineer electrical and mechanical examination.
Have you annexed any document?
Yes. In my IA, my lord, at page 177, my lord, I have annexed that advertisement. IA is annexure 4169. I have brought this matter before his lordship, but it was not considered
Which one? 177 is advertisement.
advertisement.
Okay. IA is. You said IA also?
IA is 169. I have annexed this advertisement in the IA.
Okay. Where is your application in the advertisement?
But in page 182, clause E, the junior engineering common recruitment examinations is tentatively scheduled on 11/1/2026 Sunday, my lord.
Is 182.
11/01/2026. Page 182, my lord. 82.
182. In which para?
Clause E, my lord.
But last date of form fill-up was over sometime.
Yes, my lord.
It was 10/10 or something.
My lord, I have applied.
Where is your application by which you have applied?
Lord,
No, what happened to this IA? It was not listed over.
Your Lordship, this IA was never listed.
it was never listed. We have in fact,
I mean, that should have been pursued because, yeah.
my lord, we have, and in fact,
17, I think you have filed it on in the month of 25th September or something like that. Correct?
yes,
And the judgment was reserved on 2/9.
2/9.
So immediately, almost
My lord-
immediately you have filed. You should have pursued.
No,
it.
my lord, we were hoping that judgment will be passed a bit
Judgment
urgently.
takes time. You know about this.
I agree, my lord. But then, my lord, we have even, I have requested the registry. Registry had also spoken to the registry in the principal seat, principal bench. My lord. But then it was also informed that this has been placed before the his lordship, my lord. But at least that whatever his lordship has found, I mean, I'm no more this thing. But then, my lord, at least during this examination, after the hearing, some developments took place. I have apprised.
This last date is okay, 10. You applied whether admit card issued? No.
No, my lord, since I am already debarred, so they have kept it pending.
So where is that order informing you that
No.
the matter is kept?
My lord, no order.
No any refusal?
No.
You made any representation there?
No, my lord. I have written I have informed, but I think I have not annexed that letter where I have informed.
See,
that-
you have already applied for it, right? You have already applied for it, and 4/12 the judgment was pronounced, and it was till 4/12 only. Now you are free. What is
My
the,
lord, the last date of submission is also over.
that he could have probably submitted a representation there, seeking for this, because because examination is going to happen only in the month of January, and you have already applied for this, and time period of your punishment is already over. That he could have probably approached that commission. Because that debarment is already over.
But I have
Whether the department or the SPP has published the list of candidates.
yes, but then my name is not there because I was already debarred.
Hotel also?
No information. So
No information.
no information.
You did not make any representation thereafter.
Well, we have informed that we are. Well, may I just go through the records? It may be taken up after some time.
Some time.
Yeah, I have informed the Public Service Commission that I have applied.
Because in the it must have published that these application, rejected applications. Name.
But I'll just seek some instructions also.
Okay.
Can be taken up after 5 minutes or 10 minutes?
Okay. We have not annexed list of the candidates. Okay, you obtain instruction. And then if the list of the candidates were, it must have been reflected that this application has been kept pending because of so and so.
I'll just come back, Malan.
Okay.
But I think it's, basically, since we have already applied for it, and you were aware that now on the 4/12 you were aware. That the time is over now, judgment has come. The submitted the representation by this time they will be allowed their things.
No, Malan, till the judgment is there, that earlier debarment for 1 year. That,
The judgment, isn't it?
yes.
4/12/2025. 4/12/2025, at least 5/12/2025 you were aware that the judgment has come. So if you would have submitted a representation by this time, you would have considered it. Otherwise, in your case also, you are not finding any fault with the judgment, correct? There is
Not at this stage, yes, my lord.
fault with the merit of the case.
Except, my lord,
It should be considered, the case should be
my
considered.
lord, when it is,
You are not challenging the single judge or judgment on merits. You are only suggesting that it should be modified.
another ground is, my lord, when the order is, when the relief is being molded, it should be beneficial to the parties. Yeah.
Only thing is that I was not considered.
Normally, it can, in the order, it cannot be directed from the date of the keeping the judgment reserved. It is only from the date of passing the order only. Anyway, often
And I'll get instructions.
Item number 4.
Wait, please, Lordship.
Well, there's a caveat that may be discharged.
okay. Caveat, there's a caveat.
Yes.
Since Mr. Rao passed the Pangis, then counsel for the caveat respondent appear and will be heard. The caveat stands discharged, huh? Okay.
My lord, this read appeal is directed against the judgment and order that at 18/12/2025 passed in WPC number 315-269-424, whereby the learned single judge dismissed the writ petition filed by the present appellant, my lord. Now, my lord, the only issue, the learned single judge also has noted that the only issue is when the DPC has already been initiated under relevant rules at that period of time, can the DPC, holding of the DPC be installed? And in the meantime, a new recruitment rules is brought out, and then now an attempt is being made to fill up those vacant posts under the new rules. And my lord, there is a categorical findings that the earlier DPC has not been cancelled. Government has made a statement that has been cancelled, but His Lordship also found that there are no substantive records or evidence that this was cancelled. Only they have kept in abeyance, my lord. My lord, here the facts are that
Earlier DPC cancel means not yet cancel. Earlier DPC means DPC.
only one in the private respondent's affidavit in 315, they have annexed an order saying that it is kept in abeyance. Now, my lord, here the facts is that 19 posts arose between 9 March 2022 to 30/11/2023. In Arunachal Pradesh Police, there are 3 units, my lord. One is civil police, one is Arunachal Pradesh Battalion, and another is IRBN. And all these are governed by the Arunachal Pradesh Police rules as amended, my lord. So, Your Lordship, on 14/9/2023, the final seniority list was forwarded to the Director General of Police by the Home Department. And in that letter, forwarding letter, also they have mentioned that please initiate the DPC process. Accordingly, my lord, the office of the DGP issued WT message to all and they have fixed the zone of consideration. And finally, on 21/12/2023, a formal proposal for holding the DPC with all the records, including the rules prevalent at that time, was forwarded to the Home Department, my lord. But the Home Department just kept doing nothing, kept it pending. They did nothing. They awaited the holding of the DPC, my lord. Now, my lord, I'll just take your lordship to page.
So are you agreeing by the new rules?
Yes, my lord. Because in the new rules, actually the sanction post for the APPS entry grade for IRBN is 33, my lord. And the recruitment process is 50% by direct recruit and 50% by promotion, my lord. Now, if 33 is there, the promotion quota will be 17, my lord. 50%. Now, in these new rules, they have introduced a system whereby, on the basis of strength of the respective inspectors, which is the feeder cadre, my lord, they have fixed the promotional quota, my lord. Now, in the cadre of inspector, we only 15.36% are from the IRBN, and that's why in the promotional quota, they have fixed only 15.36, and it comes to only 8 posts, my lord. So whereas we are under the sanction post, we are entitled for 17 posts. But because of these new rules, we are getting only 8. And that virus we have challenged, and it is pending in the division bench, my lord. So now the question to be determined is which rule will prevail when the DPC process if the DPC process was initiated. Now, my lord, they have taken the ground that this 2006 DPC had a lot of discrepancies and defects, but those discrepancies and defects were not spelled out. In, my lord, may I just take your lordship to page 167, my lord. (167), my lord. This is a reply to our RTI query, my lord. Page 167, my lord. May I just take your lordship to page 168. Point number 4, my lord. This is dated 12 June 2025. Whether the 2006 APPS amendment recruitment rules was defective in nature or not. If defective, can the DPC conducted by the recruitment rule be considered as erroneous promotion under Article 3 and census? The answer is on the right side. As per available records, no such defects is recorded in relation to the 2006 APPS amendment recruitment rule, my lord. Now, my lord, I pose myself, my lord, if the stand of the government that the rules were defective and discrepancies were there, these rules remain for almost 20 years, my lord. 19 years, my lord. And during the subsistence of this 2006 rules, total 76 officers 76 inspectors were promoted to the entry grade. My lord, I have annexed all those orders from page 170 onwards, my lord. 76. Now, my lord, the malafide intent or extraneous consideration of the government, my lord, it is well exhibited, my lord. May I just take your lordship to page 92. Page 92. Page 92. My lord, this is a representation submitted on 4/2/2025. Then in my lord, 94, para 4, I have clearly stated that DPC has been initiated and why it is not being taken up. Now, what is the reply, my lord?
Seeking for the interim relief.
Yes, my lord. My lord, now the government will initiate the process of DPC, and if this 2025 is annexed, implemented, our post is only 8, limited to 8. Out of that, already 4 has already been occupying that higher post. Only 4 will be considered. Whereas if the 2006 is considered, then out of that 17, 13 will be considered. Now, my lord, the malafide intent, page 99, my lord. While forwarding this my representation to the DGP, what the government is saying. May I read, my lord? Subject: forwarding of representation for conducting DPC in respect of promotions of senior most inspector. Page 99, my lord. Forwarding of representation for conducting DPC in respect of promotion of senior most inspector APP, APPBN, and IRBN. With reference to the above mentioned subject, I am directed to forward here with the representation number NIL dated 4/2/2025 received from Sri Badun Borang, Inspector, 5th IRBN, attest to the Honorable Chief Minister Security Cell, Itanagar. As per the direction of the authority, it is requested that the RR be expedited for necessary action, my lord. Now, my lord, this itself shows the malafide intent of the authorities, my lord. They are hell-bent on denying us. Then, my lord, the reasons for delay has been given, my lord. My lord, may I just take your lordship to page 180. Lordship, 180. This is also an RTI reply. Point number 1, my lord. Reasons for delay / non-holding of DPC meeting for the promotion of inspector to APPS min grade, despite proposal made by PSQ dated 21/12/2023. Right side, my lord. Due to non-finalization of APPS Amendment Rules 2025, my lord. They were just waiting for the rules to be amended. Now, in the affidavit of the state respondents, they have not annexed any order, one, the cancellation order, or the reasons why there is defects and discrepancies. They have their only justification for amending this rule is that those who has entered in the cadre of sub-inspector of police, in the civil line, there is stagnancy, and IRBN, since it was a new department, new branch, so they got early promotion to the post of inspector, and comparatively, though the civil officers of inspector who joined service as SI earlier than the IRBN people, but got promotion at the later stage, and therefore there is stagnancy. My lord, my respectful submission was that stagnancy cannot be applied in one-sided. Now, my first submission was, yes, there may be some stagnancy in the civil police, but the same formula will apply to the IRBN at the later stage, because the inspector in the IRBN, they are younger. And once they go to the entry grade, they will be there for many years. And whereas those who are in the civil line, they have almost reached the age of superannuation. So there will be subsequently at the later stage, there will be more promotional post vacancies will create because of retirement. But for IRBN, there will be stagnancy. Now there may be stagnancy in the civil police. And secondly, my lord, the stagnancy, principles of stagnancy cannot supersede the provisions of the law, my lord. Now, my lord, the government also has relied on state of Himachal Pradesh versus Rajkumar case. I also cited the same judgment. Now,
Yes.
2003, 3 SCC, my lord. 2003, 3 SCC. 2023. My lord, they have insisted on the distinction made in the Rangaya case. But the facts of each case was different. My lord, may I just take to paragraph 17, my lord. Here the Rangaya case background has been given, page 17, paragraph 17, my lord, page 788. The question that arose in Rangaya case related to mandatory obligation under the old rules to prepare an appropriate approved list of candidates and also the number of persons to be placed in the list as per the vacancies available. My lord, in the Rangaya case, there was a requirement to prepare a panel of list for consideration of promotion, and that panel has to be prepared within the month of September, my lord. But in that case, no such panel was prepared, And in that circumstances, only in Rangaya case, Honorable Supreme Court has said that you will have to fill up as per the all rules.
You have filled up as per all rules.
Yes, my lord. Now, my lord, may I take your lordship to paragraph 80.
So, we observe that there is no obligation,
Yes, my lord.
no obligation for the government to make appointments as per all rules. If there is a restructuring, they want.
Yes, yes, my lord.
Because if there is a necessity for doing
My lord.
that.
And but then, yes. But it also provided that all these actions has to pass the test of Article 14 and 16, my lord. They cannot do it whimsically or without any reasons. May I just take your lordship to paragraph 80 also, my lord. Paragraph 80, my lord. Lordship, what, paragraph 80. Yes. May I read, my lord? 80. The court considered a large number of decisions that distinguished Rangaya case and held as a matter of principle that rules that exist on the date when the case of promotion was taken up would hold the field, my lord. The court further observed that there is no rule which specifically mandated that the vacancies prior to the amendment must be filled as per the rules that existed and not the new rules. This is a complex reverse of the judgment said to have laid down in Rangaya case. This distinction is when the rules does not provide, there is, yes, government has the power to amend and fill up the posts on that basis. But then, my lord, once the DPC has initiated, there has to be then, my lord, 82.3. I just want to read this. 82.3, my lord. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to the amendment of the rules. The employee does not acquire any vested right to being considered for promotion in accordance with the repealed rules in view of the policy decision taken by the government. There is no obligation for the government to make appointment as per the all rules in the event of restructuring of the cadre is intended for efficient working of the unit. The only requirement is that the policy decision of the government must be fair and reasonable and must be justified on the touchstone of Article 14. Madam. Now, my lord, another aspect is His Lordship Malat 2025 2 SCC Malat, phase 1. This decision is by 5-judge constitutional bench, my lord. And this is a judgment on a reference by a 3-judge bench, my lord.
When it was this was disturbed by single years. Single years has considered about these things.
But then I have placed this paragraph 80, it was not discussed.
One has specifically stated that principle is being overlooked.
Yes, my lord.
So once it's overruled, then what is the point of bringing it again?
My lord,
If we read the statement in YG Rangaya versus Srinivasana, that the vacancies which occurred prior to the amended rules would be governed by the old and not by the amended rules, does not reflect the correct proposition of law.
my lord, my lord.
The states under so and so, it is hereby overruled.
No, my lord, the background, the facts in this case was that the state government, they created 5 posts, but then they did nothing. They did nothing because there was some problem was there. So,
Actual things we are not doing.
yes,
So here there is a ratio laid down. The ratio is that the vacancies which occurred prior to the amended rules, in your case also, would be governed by the old rules, not by the amended rules is overruled. So that principle has been laid down.
yes, my lord.
In your case also, what has happened is that the vacancy arose earlier. When the DPC was going on, then the state amended the rules. And as per the amendment, you are being aggrieved by that. Because they want to now fill up the post with the amended rules, correct? So that now this, case law that has been cited by you, that specifically says that earlier rule, what Rangaya
My
was.
lord, yes. My lord,
That statement is being overruled. So now the ratio which is presently before us is that whichever is the applicable law, prevailing law, that will be followed.
my lord, I have never asked on the basis of principles laid down in the Rangaya case. Yes, my lord. My lord, yes, yes.
Not arguing that's a different thing. But
No.
there is a law set by the Supreme Court, we have to follow that.
Now, my lord, this case, it is if the rules does not provide anything, and if that is the case, there is no statutory requirements to do certain things in a certain manner, then, my lord, this is applicable. That is agreeable, my lord. But, my lord, my case is slightly different. My case is once the DPC has been initiated, the rule of the game cannot be changed midway. Now, in my case,
It says that like if there is an amendment that the prevailing law will apply. Though the vacancies were arose earlier. But
now, my lord, my case is slightly different. Here, there is a plain post is there, plain rules and new rules has been brought out, and in that situations, this law will apply. But
Mr. Patil, all the cases, whichever comes to the court, the facts are different. Always, there will be some difference here and where there will be there. There will be some similarities in some cases.
my lord,
But the law remains the same, correct, for all the cases. Now, whatever the ratio and the principle laid down by the Supreme Court, that has to be followed, correct? Now, in this case, apparently it has been stated specifically that that filling up of the post will be done as per the prevailing laws.
Yes.
Laws, though the vacancies arose earlier. That was the law that was set.
now, my lord, there is a difference between paragraph 80 and 85.5. 85.5. 80, my lord, I have just read this 80. Yes. Paragraph 80. Yes. The court considered a large number of decisions that distinguish Rangaya case and held as a matter of principle that rules that exist on the date when the case for promotion was taken up would hold the field. So therefore, yes,
So observation made. Then you carry on reading.
yes. The court further observed that there is no rule which specifically mandate that the vacancies prior to the amendment must be filled as per the rules that existed and not the new rules. This is a complete reversal of the principle said to have been laid down in the Rangaya case. But there is a slight distinction between
So no,
this Rangaya case, this case and
observe. The Rangaya said something, earlier it was said something, though there is no specific.
yes,
Now, when we come to 80, now they
85.1.
Then they come to 85.1.
Yes.
85, they come to the farm. They can read from 85. 85, 85.1.
85 clarifies everything actually, madam.
So 85.1.
85.
Sure. We actually did that like this year, but.
No, my lord, for this paragraph 80, further clarification has been given by the Constitutional Bench, my lord, reported in 2025 to SCC. Yes.
Reported.
Page 1, reported in 2025 to SCC, page 1. Let us, my lord, let us come to page 12.
Page 12.
12,
Paragraph.
paragraph 1. Yes, this Pukas case.
Paragraph of page 12.
Page 12, paragraph 1.
Yes.
A three-judge bench of this court, while accepting the solitary principle that once the recruitment process commences, the state or its instrumentality cannot tinker with the rules of the game, insofar as the prescription of eligibility criteria is concerned, wondered whether that should apply also to the procedure for selection, my lord. Now, my lord, main purpose of this reference is, yes, selection. In that context, doubting the correctness of a coordinated bench decision in K such and such for not having noticed an earlier decision in such and such, it was directed that the matter be placed before the Chief Justice for constituting a larger bench for an authoritative pronouncement on the subject. Then, my lord, come to page 13, my lord, page 17, my lord.
Page 17.
Yes, my lord.
Page 17. Yes.
Paragraph 14 and 16, my lord, and then 65. Yeah, scope of reference. In paragraph 14, I'll read. In various judicial pronouncements, the law governing recruitment to the public service has been colloquially termed as quote unquote the rules of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that the rules of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. One which prescribes the eligibility criteria, that is essential qualification of the candidate seeking employment, and the other which stipulates the method and manner of making the selection from amongst the eligible candidates. Cut off that 15 is 16, Malak.
Which are the things it cannot change? Which are the things?
Yes, cut off that with reference to which eligibility has to be determined is the date appointed by the relevant service rules. Where no such cutoff date is provided in the rules, then it will be the date is appointed in the advertisement inviting applications. And if there is no such date appointed, then eligibility criteria shall be applied by reference to the last date appointed by which the application were to be received. 60, Malak. The law is settled that after commencement of the recruitment process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per the advertised criteria. Such alteration oblique change, therefore, deprive a person of the guarantee of equal opportunity in matters of public employment provided by Article 16 of the Constitution. This reference order, therefore, acknowledges this legal proposition that and in clear terms accepts that the rules of the game cannot be changed after commencement of the recruitment process insofar as the eligibility criteria is concerned, Madam.
In your case, there is no way such eligibility criteria.
Eligibility criteria.
See, where, I mean, one advertisement has been made saying that only graduates can apply. Correct. The advertisement has been published. After that, they say, no, not only the advertisement, the graduates, no, you have to have MA degree. That they cannot do eligibility because you are depriving other people. That's the eligibility criteria is not, I mean, in your case, there is nothing like eligibility.
No, my lord, in this present scenario, our
Rules of the game, the principles of rules of the game cannot be changed. That has been described here, explained also properly that which are the criteria we cannot change. That has to remain changed till the game is over. And which are the things you can tinker with, government can tinker with. This is what this husband can say. So
now,
there is no eligibility criteria is not involved at all. Here, only thing is the government can change the policy regarding that proportion,
Yes.
or proportionality of
Exactly.
how many people come from the promotion,
Exactly.
come from the district, from the direct recruitment. That has been changed. That is not eligibility criteria.
now, my lord, here,
That we get better candidates from the direct recruitment. Then they may increase it. They may think, oh, we should give proper representation to the people from the side also.
now, my
So according
my lord,
that's the government policy.
my lord, in our case, it is only concerned about the promotional quota, my lord.
Killing the virus. That is, so you'll have to wait for that. You have to see what what is there. If the rule is bad, then rule will go, then will be considered. But in the meantime,
Now, my lord, because of these new rules, our eligibility criteria has been done away with.
eligibility criteria is something else. Eligibility criteria is not like that. Eligibility criteria has not been changed. You are inspector. Your eligibility criteria is that you have to be an inspector.
Yes.
That hasn't been changed. Or like, you inspector having 5 years.
Yes, yes.
experience. That is an eligibility.
Yes.
criteria. So if that, if that would have been changed, then it could have been different things. But that hasn't been changed. Only the numbers have been changed because of, that's because of certain reasons which is.
Then, my lord, I'll just take your lordship to the conclusion part, 65.65, paragraph 65.
This case.
Yes, my lord. 2025 case.
Case because case, right?
Yes, my lord. 30 page, that is 7. Conclusions, my lord.
Yes, 37. Which paragraph?
65. Conclusions, my lord. We therefore answer the reference in the following terms. 65.1. Recruitment process commences from the issuance of the advertisement calling for application and ends with filling up of vacancies. 65.2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Then there's another.
In my opinion.
Yes. No, correct.
Your lordship sees the words used. This is in respect of direct recruitment.
In the reference, it is clearly mentioned that insofar as the eligibility criteria is concerned, wondered whether that should apply also to the procedure for selection. So selection is promotion. It's also mode of recruitment. So this applies to the selection process.
Yes, selection process means when advertisement is made, then there is they will give, how many posts are there. So if there are 15 posts, then how many will be from the direct recruitment and how many will be from the promotee side. So then there will be eligibility criteria. That eligibility criteria they cannot change. That's what this case is.
And so far, my lord, other considerations, I just want to cite one recent judgment, the Supreme Court.
Citation.
Civil Appeal number 4467-4468 of 2023. But here the factual aspects are slightly different because they have pertaining to some executive orders prescribing certain quota through an executive order, which is not provided under the rules, Malad. But then the way it was carried out, all those things. But may I just take you also to paragraph 42, Malad. 42 to 46, Malad.
Okay.
2 to 46, Malad.
Yes.
Page 37, Malad.
Yes. Yes.
Applying the above principles of law, it can safely be concluded that executive instruction issued under Article 166(1) of the Constitution cannot override the act done under TPS rules framed under the proviso to Article 309 of the Constitution of India and the regulations framed thereunder. The executive instructions can be used to supplement the rules in case of ambiguity or if gaps are to be filled, but such executive instructions cannot supplant the specific provisions of the TCPS rules, which already occupy the field. It is not the case of the government that to fill the gaps and to supplement the TPS rules, NRP is relevant. In absence thereof, in our view, the action of the government cancelling the process of recruitment for TCS and TPS midway is not justified and is arbitrary. It is further relevant to discuss that pretext which has taken to issue the cancellation memorandum is the NRP dated 5/6/2018. The said policy is based on recommendation of the 3-member committee constituted by the state government to review recruitment policy across the state and all its department. The recommendation of the committee were plain and specific. Inter alia, observing that all the above recommendations will be applicable with prospective effect only. In addition to the discussion in absence of the statutory backing of the policy, the recommendation as made limiting the marks of interview at worst would only apply prospectively, meaning thereby it shall not apply to the recruitment process for TCS and TPS, which had started way back in April 2016, and the preliminary as well as the main examination has already been conducted. Hence, application of the policy decision on the pending recruitment process is contrary to clause 2 of the said policy. The plea of larger public interest. It is vehemently argued that the issuance of the events and cancellation memorandum is because of change required to make the process fair, transparent in larger public interest. It is nowhere specified as to how, due to NRP, larger public interest can be achieved. And after bestowing our consideration, indeed, it can be observed that the executive does not have a discretion to bring policy and to implement the same, applying the rule of law. Once the process of recruitment is notified, following the subordinate legislation, such general policy cannot occupy the field which is already occupied by the provisions of the statutory rules. 44. Regulation 11 vividly indicates that the interview should be of how many marks. As such, the same cannot be supplemented by NRP, which is in the form of executive instructions, and to rely upon said decision. Cancellation of the process of recruitment by issuing cancellation memorandum is not justified. In our view, the claim that the policy decision was in larger public interest is wholly unjustified. Rather, it is antithetical to public interest. On the basis of the stand taken and the materials placed in our considered opinion, the state has miserably failed to discharge the burden to substantiate that the decision of the cancellation of the recruitment process was in the larger public interest. Change of rules of the game after the game has begun. 45. The recruitment process under the advertisement for TCS, TPS comments on the date of issuance of its issuance. At the cost of repetition, and as discussed above, much water has flown. The TCS has taken active and tangible steps to conduct the preliminary examination and the main examinations under the TCS and TPS rules and regulations. After all this, by issuing the cancellation memorandum, effectively setting the clock back, effectively setting the dock back and putting the entire process at naught under the garb of policy decision is arbitrary. The court in Tes Prakash Pathak has affirmed the decision of K. Manjusri such and held that the recruiting authority can devise a procedure for selection only in absence of rules to the contrary. However, the same should be done prior to commencement of the recruitment process. The relevant portion of the said judgment is reproduced as such. 52. Thus, in our view, the appointing authority, recruiting authority, competent authority in absence of rules to the contrary can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also be benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmark may be set any time before that stage is reached, so that neither the candidate nor the evaluator, examiner, interviewer is taken by surprise, my lord.
So here is the case of benchmarking. Benchmarking means eligibility.
Now, my lord, in my case, when this TPC was initiated, they have done it under the 2006 rules, and had the authorities conducted the DPC, we would have been considered for motion. And with the forwarding of the proposal to hold DPC, our legitimate expectation and then our right to be considered had eroded. But by not doing that, our right has been vanished, my lord. And my lord, as observed by the single judge by his lordship, that the government, though, attempted to explain the reasons why this is not been taken up and why there are defects and discrepancies, they have not spelled out anything. They just stated that there are the defects and the discrepancies, and therefore the government has taken a conscious decisions. There is nothing on records that what are those conscious decisions, what are the basis for those conscious decisions. And the defects and discrepancies has not been spelled out. And if there was a defect and discrepancies in the 2006 rules, as I have submitted, 76 officers were promoted to the entry grade. Now,
See before a division bench. So division bench will examine all those things, what were the defects and now, this, I think in my, this matter is also division benches.
Hmm.
Saying that, isn't it, Mr. Professor, Mr. Pandey?
My lord, the issues are totally different there, so I have understood.
Basically, the rules, they are different
Yes.
with the rules.
Yes,
There is no different issues.
yes.
We are basically deprived with the rules and which rules have been challenged.
The rules are under check.
For a division.
Yes,
And if the rules goes, then they get the benefit in this
Yes.
case also. There
Yes.
is no doubt about this.
My lord.
Both the matters should be heard together actually.
Yes.
There's no point of hearing these two matters differently. When we go, we give a different opinion and the division bench comes to a different
Oh,
opinion.
but they will be totally different. There, the virus of the rules are challenged. My lord knows. Yes, here their case is,
They have gone to the sickness earlier, but before 5
yes,
Right.
yes. Yes, yes.
They should definitely attack with the case.
But this case, there are two writ petition filed. First writ petition was that the pre-amended rules should apply in terms of Rangia. The other writ petition was that the rules of the games cannot be changed. So these are only two grounds. So this can be decided on these two grounds, my lord. My lord has already seen. Rangia case was, my lord, in 1983. That was never categorically reversed by the Honorable Supreme Court itself. So they analyzed so many judgments. Thereafter, they came to a conclusion, my lord, that the pronouncement in Rangia is.
See, I mean, now, this, if we decide this, if this bench decides this matter, and some other, result comes out from that, then what will happen?
My lord, this will be decided on what has been pleaded in this case, my lord. This will be decided on what has been pleaded in this case. Yes.
Like if we allow this,
Yes.
if you allow this, if the virus is changed there,
Yeah.
the virus is stuck down there, then
Yeah.
what happens?
But that is another thing, my lord.
That has to be seen.
Yes.
My lord,
If your lordship is not passing any interim order, my lord, I have no issues.
no, there has
If
to be,
there
my
is
lord,
to be
I will,
then I'm going to argue on the merits of this case. These two judgments are not even, how can this be applied in the facts of this case? There cannot be an interim order. This will have to stand on its own legs.
Because the virus has been changed, they are basically, see, if you see the whole thing, they are basically agreed by the rule.
My lord, I have understood.
They are agreed by the rule.
Yes.
They are agreed by the rule, and like, only thing has happened is that they have filed a petition with
That I have understood, my lord. I have no objection to this being taken along with the virus challenge rules. But there cannot be a stay order in these cases, my lord. If any stay order in these cases will have to be granted by this honorable with due respect, my lord, on the merits of this case. Yes.
Moreover,
I will show these two judgments are totally misconceived, my lord. So far as the facts of this case, your lordship has already, my lord, seen that. So if your lordship takes it along, my lord, without any stay order, my lord, I have no objection. Otherwise, I may be allowed to argue, my lord. Because any stay order in these cases will have to be on the merits of this case, my lord.
when is this process? This is starting, no?
Hello?
When is it happening?
DPC? No, I am not aware of.
I have informed that they have already started moving. My lord,
Because, my lord,
for holding the DPC, because
in the,
they are in a slightly better position. So, and my submission is that once the promotion is granted, is considered, well, this writ petition, writ appeals also be,
in fact, my lord,
Lordship, so for DPC is concerned, Lordship, that part, Lordship, I need to take instruction, Lordship. But what I would like to submit is that, Lordship, in promotion matter, because it involves the Lordship public interest, we need manpower in the higher Lordship, cadre Lordship. So basically, in promotion matter, Lordship, interim usually the court does not Lordship, provide Lordship. It depends, but
You are not committed from last how many years?
Lordship, last
since 2020,
2020.
20. Yes, my lord.
So, but
And then, my lord,
the rules at the point of time.
but
No, I make this.
so therefore we are already suffering Lordship because in the higher Lordship, cadre Lordship, we need manpower Lordship.
may I suggest one thing,
So
my lord?
yes,
May I suggest one thing, my lord? Since there's already steps have been taken
and that virus case. Can we fix it in the first week of January or second week of January? And then till then, my lord, let there be no DPC.
May I point out, my lord? In the rule challenge case, my lord, stay has been declined. Where is the question of my lord passing any order by coordinate bench now? Yes. Stay has been declined in that case, my lord. Stay was declined in that case. It was categorical held that the procedure may go through. So any contrary order to that would be, my lord, by coordinate bench would be difficult. I was not thinking that otherwise brought the order. Yes. Yes.
They're just thinking
Yes.
whether this.
So that is what I'm pointing out, my lord. There was a, yes,
There is some effect on this also.
yes.
Or,
Oh.
I mean, if something is.
That's why I'm just pointing out your order. That in that case also where a virus of the rules have been challenged, interim order was prayed for. That has been declined, categorically declined. So, my lord, in this case, any interim order, my lord, that would be contradictory to what has been already passed by a coordinate bench. That is what I'm submitting, man.
Provided not take the matter together.
Yes. Then I will be given opportunity to argue.
My lord, the DPC has not been conducted from 2020. And
That is because the
another
department
10,
has
15 days will not make any
That
much of
is-
difference.
That cannot be a ground for granting of stay, my lord. Stay will be granted on its merit.
That cannot be ground for prolonged the lawsuit, DPC pardon.
That's another thing. Like, what do you think? This matter should be tagged together or it should be heard?
I think it should be taken.
My lord, it should be hard differently, my lord. Because earlier these prayers would have been made by the learned counsel for the petitioner, my lord, elder brother. All along he pursued this case. The matter was heard. A judgment has now been rendered by the single bench, rejecting the claim of the petitioner on valid grounds, my lord, in my humble submission. Rangia case now has been overruled. And this Tej Prakash Pathak is a case, my lord. My lord knows a judgment is a precedent over what it actually decides in the facts and circumstances of the case. And this Tej Prakash case was a reference whether Manjusri was a good law or not. What is Manjusri? Direct recruitment, my lord. I can show it. I brought it. So Tej Prakash case does not even help him. In fact, your lordship will see the words used. The selection process starts from an advertisement, culminating in the drawing of a select list. Where are these words ever used in the case of promotion, my lord? Yes. Yes. So, my lord, in my humble, if your lordship does not take it, my lord, there is no question to stay order, my lord, in my humble service. Because ultimately the appellant will have to make out a case for this honorable court to grant any stay, my lord. I can produce the order of the coordinate bench, my lord, if your lordship permits. It will take some time, but there's a categorical declaration of the interim prayer.
In fact, my lord, in the 315, there was an interim observation that since the DPC has comments from 21.
Yes, independently also. Yes.
What is thinking?
Yes.
Because basically he's doing by this.
Yes. I understand. Yes.
Virus has been challenged.
Man.
So whatever the court decides.
Yes.
It will have some.
Yes. That is there.
They say that the rule is bad.
Yes. That I have understood.
It's better that we take it together, whatever is decided.
Yeah, my lord will take it together, my lord, but without any interim order. My lord.
The division will decide
No.
that the rule is bad. Then they have a case.
Yes.
Then they have a case. Now, if we decide it, I mean, like now.
Yes, my lord, I have absolutely no objection. Your lordship takes it along with that. But what I am submitting is there cannot be any stay order in this case because then, my lord, I have no objection, my lord. Because my learned friend is insisting for an stay. That's why.
If stay is needed, then the other bench will decide.
Yes, my lord. Yes. Yes, because there is already a declination there. That there shall be no stay.
We are not thinking about the stay. We are not thinking about whether it would be a good idea to take it with the other matter,
Mm.
or it will be a good idea. That's what I'm thinking of, if or not. And if it is a good idea, then it's better go there because that will have effect on this. What
My lord.
separately decide this matter, ultimately if the rule is struck down, then it will have an effect on this.
Yes, yes.
So
That is, yes.
And suppose if the DPC is held as per the new rules.
DPC will have to be held as per the new rules, so long as the rule is not struck down.
If the vacancies are filled up, then this should rather infract us. No.
No, my lord.
This petition,
It has to be reconsidered again, Lord, in that case.
It has no connection with that, my lord.
My lord, once promoted and then again taking off their position.
See, they have to be held. And if you are promoted, then you're this rule is being challenged again by you. What happens to that case? If it is said that the rules are good, then
My lord, under these new rules, four of us will be considered. Those who are senior to us.
it has been held.
We are not arguing the rule case, my lord, but that petition is misconceived totally.
My lord, otherwise, I will be agreeing to that taking up together and then fixing a specific date early so that the can.
No, I have no objection to that, my lord.
Where is the case, Mr.?
Not that.
No, my lord.
Well, we can fix a date either on 21 or 22.
Yeah, I have
January.
no objection, my lord.
I mean, only thing that looking into looking into the contents of the very carefully. It will be better to fix it on the tag with the other matter, or we can take down that number,
Yes,
take it and fix it on 22nd or whatever.
yes.
WPC 341 of 25.
See, there will be some effect on this.
Yes, yes.
That is why we want to send it. Otherwise,
I have no objection to that, my lord. Yes.
Ms. P. Patil.
after consider.
P. Patil, starting counsel for the applicant. Also have Mr. Kapil, resident government advocate for the state government, and Mr. Pang for private respondents.
Let it be on 21st. 21st.
The
Let it be on 22, my lord. Other matter.
But I'll just take instruction from in that earlier case.
is pending before the division bench. Number is the number, huh?
Yes, I will just find out and give.
Okay. In view of the above, and the same, and both the petition, the petition and the appeal can be taken up together. In view of the above, let this matter be listed on
22nd.
22nd, along with the writ petition. Huh?
I will give the number.
That-
No, that's a writ petition, challenging the virus. Writ petition.
Okay.
My lord is just taking it along, my lord, without any
Yes.
further. Obliged. Highly obliged.
Item number 5 and 6.
May I, your lordship?
No, this is. Yeah.
May I, your lordship? Lordship, as per the office note dated 22 to 12/22/25, neither AD card nor unserved service notice has been received, your lordship, as per the office note. Upon respondent number 4, your lordship. In item number
Item 5 and 6.
5, in item number 5, in respect of respondent number 4, and in item number 6, in respect of respondent number 5 and 6, Your Lordship.
So, it's not yet received.
Lordship, as per the office note, it says neither AD card nor unserved notice has been received, Your Lordship.
They might have received, my lord. They are the government employee. Because of non-completion of service, I am being deprived.
You know, we go by the office note.
Yes, my lord.
Otherwise, it's on the
Hard miss.
Of course, no, lord.
And Anju,
Because they are the government employee. Service was served through the
for
DGP.
the appellant, Mr. Deori, for the respondent number
I am for respondent number 3.
3. The office note is
Petitioner.
22/12/2025 with that, the notice upon the respondent number 4 and only 4.
In item number 5,
Okay.
respondent number 4.
5.
Yes, Your
4
Lordship.
is still awaited. In view of the above, let this matter be listed after
After 2 weeks, Your
2
Lordship.
weeks.
In next item,
And
item
in-
number
in
6,
Respondent number
5 and 6, same order,
5 and 6, huh?
5 and 6.
Okay,
Obliged.
still awaited.
Item number 8.
You just need to dispose of UV effect. This higher probably.
What is this arrival for?
Higher item.
Who's appeal? You're not there.
For the state,
No,
Your Lordship.
So there, and on the upper template, just higher the present interlocutory application was filed in the dispose of public interest litigation seeking to bring on record certain subsequent development. The public interest litigation number, PIL 16 AP of 2023 has been dismissed by the division bench by judgment and order dated, judgment dated 25/4/2025. Stop. However, due to inadvertence, the present interlocutory application remain undisposed. In view of dismissal of the main PIL, no further order survives for consideration in the interlocutory application. Stop. Accordingly, the interlocutory application stands disposed of as having become infructuous. Okay.
Item number 9.
May it please your lordship. Milord, in this, Milord, the petitioner was dismissed from service, Milord, and this is the subject matter of the writ appeal, Milord. There is a delay of 230 days, Milord, in preferring the appeal. The delay, Milord, basically the petitioner has been contesting this case from 1991 onwards, Milord. So 34 years, Milord, he has contested this case, Milord. And-
objection.
No, my lord. No, my lord, delay may be counter, my lord. Will, my lord, examine on the merits of the case.
Mr.
Ila, lordship.
Now counsel for the applicant. Also had Mr. Kaso, huh? And Lanet DSGI
For all the respondents.
representing all the all the respondents. Staff. Para. This is an application filed under Section 5 of the Limitation Act 1963, seeking condonation of delay of 230 days in preferring the connected writ appeal. Against the judgment in order date 11/12/2024, passed in WPC number 28, 2018. Par. The ground for delay in preferring the connected appeal as explained in para. Which para?
Paragraph 11, Lordship.
Which paragraph?
Para 11.
Para?
11, Lordship. Page 7 of the petition.
Okay, paragraph 11 of the condonation application. Stop. We have perused the ground stated in the above paragraphs. Also heard learned counsel for the parties. Stop. On consideration, we find that the applicant has been able to show sufficient cause for not preferring the connected appeal on time. Stop. Moreover, Mr. Kato, Lane DSGI, has raised no objection in condoning a delay. Stop. In view of the above, the delay of 230 days in preferring the connected appeal is hereby condoned. With the above, this IS stands allowed and disposed of. Okay.
Milord, can the writ appeal be taken up on 7th of January, Milord? If possible,
Okay.
also.
And the registry is shall register the writ appeal and place for admission on
7th January, 7th of January, Lordship.
27 of January. Okay.
Lordship.
Pass
I'm
over
obliged.
matter item number 3.
I'm obliged.
My lord, I have, yes, I have submitted an application. Not, sorry, I only one intimating that on 5/10/25, I have submitted my, fill up my forms. The last date was 10/10. And this 5/10 and then submitted on 7/10 in the
Last year was 10/10.
10/10. I have filled up this through electronic system on 5/10. My only submission is that pending the writ appeal, subject to the outcome of the writ appeal, I may be allowed to just participate in the examination.
Mr. Important. Land counsel for the petitioner.
Lordship.
Thus, appellant, huh? So what is your submission?
My submission is, Your Lordship, since learned single judge has already exercised
Okay.
his discretions, Your Lordship, and already the quantum has been molded to ensure justice. So therefore, this appeal may not be entertained, Your Lordship. So I'm praying for dismissal of this appeal.
Okay.
There's no any error in law, fact, nor defect in the single judge judgment and order, Your Lordship.
Also had Ms. Ananju, Learned Standing Counsel for the Arunachal Pradesh Public Service Commission. Stapa. The appellant, comma, a person with locomotion disability. And wheelchair bound is aggrieved by the judgment and the judgment dated 4/12/2025 passed by the learned single judge in WPC number 364/2025, whereby the writ petition was out. And the punishment of debarment imposed by the state public. It was imposed by the State Public Service Commission. State Public Service Commission. Arunachal Pradesh State Public Service Commission was modified to the period undergone so far in the opinion, period undergone till the date of delivery of the judgment. Start. Para. The grievance of the appellant is that though the single judge found the punishment for a period of 1 year to be harsh, punishment of 1 year, debarment to be harsh. The relief was molded till the delivery of judgment. Adopting a pronouncement of judgment on 4/12/2025 instead of the date on which argument was concluded on 2/9/2025. This has resulted.
IA was filed on 25 September.
Okay. Although an IA was filed seeking
early disposal and then for permission of to
early disposal and for permission to appear the examination, the same was not considered, which has resulted in denial of opportunity to participate in recruitment. One recruitment.
Junior Engineer Common Recruitment Examination 2025.
Junior Engineer Common Recruitment Examination 2025.
Advertised on 17 September.
Advertised on 17
September 25.
September 2025. Staff.
And then next examination date is on 11/1/2026.
Okay. 11. Yes, Esther. I have not. Having considered the submission, we are of the view that the matter raised involves examination of the correctness of the examination staff. Accordingly, the writ appeal is admitted. Issue notice. Staff. The appellant has also made interim prayer. Stop. Considering the appellant's status as a person with a disability, comma, the finding of the learned single judge that the punishment of debarment for 1 year was hers, and the impending junior engineer examination being scheduled on 11/1/2026, there shall be a stay of operation of the impugned judgment dated 4/12/2025. To the extent it restrict the appellant from appearing in examination till the said examination. Okay, stop. Examination till the said date. Stop. The respondent, Arunachal Pradesh Public Service Commission, is directed to permit the appellant to appear provisionally only in the junior engineer examination scheduled to be held on 11/1/2026, subject to fulfillment of other eligibility criteria. Okay. Then list this matter after 4 weeks. Okay.
Obliged, Lordship.
Yes.
May I please, Your Honor? Your Honor, I beg to mention item number 8, man.
Yes. Mr.
Goji, madam.
Learned Counsel. Therefore, the petition.
Yes, ma'am.
With the consent of the Learned Counsel for the respondent. When do you want to sit?
After 3 weeks, madam.
Prays for adjournment of the matter for 3 weeks. The prayer is allowed. List this matter after 3 weeks.
All right.
May I please say, Lordship?
Yes.
Lordship, I beg to mention item number 26.
Item
Number 26.
26.
Well, yes, Your Lordship, with the consent of the petitioner's party, Lordship. Lordship, I beg, you should may kindly list this matter after 3 weeks, Lordship.
Okay. Ms. Sangeeta, the Learned Government Advocate for the state respondent, with the consent of the Learned Counsel for the petitioner, prays for listing this matter after 3 weeks. The prayer is allowed. Okay, list this
Okay.
matter after 3 weeks.
Okay. Also, Your Lordship, item number 25, Your Lordship.
25 also?
Yes, with the consent of the petitioner's party.
Similar order. Okay.
Obliged.
May I please, my lord? My lord, I beg to mention item number 17, my lord. My lord, I have been instructed to withdraw this petition, my lord, as the matter has become in practice, my lord. Item 17.
Mr.
M. Ratan on behalf of L. Jilan, Lukhtar Jilan.
Learned Learned Counsel appearing on behalf of the L. Gillian, Learned Counsel for the petitioner, submits that he has an instruction to withdraw this writ petition as it has become infructuous. Stop. The prayer is allowed. Sorry, Miss, who appeared here? Okay, Miss. Okay, has no objection now. Miss Pangun has no objection. In view of the above, this writ petition is dismissed as withdrawn. Okay, on becoming
In practice, ma'am.
Okay.
Deeply obliged.
Lordship,
Yes.
I would like to mention item number 24. I'm on behalf of L. Perme, Standing Council for Agriculture.
Yes.
We're yet to file our affidavit, Lordship. Maybe list after 2 weeks.
Who is for the petitioner?
I'm for a petition.
No objection.
No objection to it.
Mr. Islam counsel for the petitioner is present. Mr.
S. Sirang on behalf of L. Perme, Lordship.
Appearing on behalf of Mr. L. Perme, Land Council for the respondent number
1, 2, and 4.
1, 2, and 4. Pray for how much time you said?
2 weeks, Lordship.
Further 2 weeks time to file affidavit in opposition. The prayer is allowed. This matter after 2 weeks. Okay.
Lordship, in item number 1, we have filed an IA for implement as a respondent number 5, Lordship.
Okay.
Yes.
I'm appearing for the petitioner in this matter. My lords, as per the last date of the last order, your lordships, there has been a direction to the district superintendent of police to file action taken report, your lordships.
May I, Your Lordship? We have received the instruction, Your Lordship, from the Superintendent of Police, Your Lordship. The FIR has been lost.
FIR lost?
Yes, Your Lordship. An investigation has been done, Your Lordship.
There are people sitting on the road, your lordships, and not permitting ingress and egress to my site, my lords, for over 3 months now.
Now what to do? You are appearing on who are you otherwise?
On behalf of the villager.
Villager. Villager wanted to be implemented as respondent here.
Yes. Affected villagers. Industrial growth center pollution affected people's bottomless.
Villager wanted themselves to be implemented in the matter. You have objection?
My lords, I don't have any objection. Let them give a statement that they will abide by law and not create any dharna on the streets.
No. They wanted themselves to be implemented
Please,
in
your
the writ petition as a necessary party, respondent party.
My lords,
You have no objection.
My lords, if they're seeking to be implemented, then in that event, they will not be taking law in their own hands, my lords. They can't have it both ways. They cannot take law in their own hands and also seek implement here. NGT has already, your lordships, taken
Now,
cognizance.
whether your IA has been listed, IA not yet listed. No, this morning only. Okay. So then this will be listed along with the interlocutory application for implement next week. From there to tomorrow, the vacation start. It will open on 7th.
Five will be open on 5 January. 1 day court is there.
Sorry, this is 26, 25.
Monday.
Okay, 5. This court will reopen on 5. So we'll take this matter along with the IA on 7th. Okay.
Please, your lordship. My lords, may I also humbly submit, your lordships, that paragraph 6 and 7, your lordships, they may be complied with. Last order, my lords.
See, they are mentioning that it's a mention time. Just wait for some time. Okay.
I'm obliged.
My lordship, I beg to mention item number 18.
Item 18?
Yes, it is listed in order. The conducting council, the Takam is outer station.
I'm
for item number 18, Lord.
Petitioner.
Yes.
You are for the petitioner.
Yes.
You are for the respondent.
Respondent number 2, Lordship. I had filed already a reply, Lordship.
Okay. So why it has been listed for? This has been listed for
order.
Order, but then what is
the
order? Oh,
actually, they
all the respondents are present.
Yes. The conducting council, Takam Sunil sir, is out of station. That's why.
Who will see the record and pass order? Okay.
Okay.
David Lords.
Yes.
Lordship, item number 20.
Item?
20, Lordship. Lordship, here, PCR has not come. PCR has not come.
PCR not had come. Oh.
Matter may be fixed tomorrow, Lordship.
You are for the petitioner?
Yes, sir.
Miss Your Miss
P. Moyo.
Learned Counsel for P. Moyong, Learned Counsel for the petitioner. Petitioner is present. The trial court record is still awaited. In view of the above, let this matter be listed after 3 weeks. Listed after
Lordship,
the
tomorrow.
receipt of the trial court record.
Tomorrow, Lordship.
Tomorrow,
Yes.
you said that TCR not received.
Lordship, then kindly fix date may be given.
So
25.
let the TCR trial court record be received. Okay.
Yes.
After receipt of the trial court record, this matter will be placed. Okay.
Okay, Lordship.
Okay.
Oblige.
May I please, Your Lordship? I beg to mention item number 16, Your Lordship.
Yes.
I need 2 more weeks to file additional affidavit, Your Lordship.
You are for the petitioner.
Yes, Your Lordship. I'm on behalf of R. Saikia, Your Lordship.
Okay. So who is for the respondent? Have you informed the respondent?
Yes, I am.
Okay. Mr.
M. Tasso, on behalf of
Appearing on behalf of Mr. Intu Saikia, Learned Counsel for the petitioner, prays for further 2 weeks. Further 2 weeks to file additional affidavit. What did you say?
Rejoin that, Your Lordship. Rejoin that, Your Lordship.
Rejoin there. Okay. Affidavit in reply to the affidavit filed by the respondent. The prayer is allowed. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks. 2 weeks, you said?
Yes, Your Lordship.
Okay.
And Your Lordship, I beg to mention item number 21, Your Lordship. We have filed IA, Your Lordship. We are waiting for a reply.
Okay, so what?
Lordship, I'm appearing for 1 and 2 in this matter, Lordship. And
IA is for what?
For reassessment, Your Lordship.
You have received the copy of the IA? Not yet.
No, the copy we have received, Your Lordship, but the instructions we are awaiting.
Okay. Mr.
M. Tasso, on behalf of R. Saikia.
Learned Counsel appear on behalf of Mr. R. Saikia, Learned Counsel for the applicant. IA also filed by you only?
Yes, Your Lord.
You are for the petitioner?
Yes, Your Lord.
Okay. Applicant, petitioner. So Miss Sangita submits that the instruction in this regard is still awaited. Therefore, pray for some more time. Prayer not being objected to by is allowed. List this matter after 3 weeks. Okay.
Applies.
Item number 1.
Yes,
Yes, Mr.
May I draw the Honorable Court's attention to the last order, Your Lordships?
Yes.
My Lords, may I read paragraph 3, Your Lordships?
Yes. Yes.
My Lords, may I read it from this? Appropriate action against the protesters, my Lords, has it, and the association of persons who have prevented the petitioner from carrying out its business.
Paragraph 3.
Paragraph 3, Your Lordships. Paragraph 3. My Lords, I'll read it from the beginning. Today, when the matters were listed, Learned Counsel for the petitioner submits that petitioner filed an additional affidavit by enclosing the details of the partners of the petitioner firm as directed, and also has enclosed a copy of complaint submitted by the superintendent to the superintendent of police, Pasighat, East Siang District, Arunachal Pradesh, on 25th of November 2025, praying appropriate action against the protesters and associations of persons who have prevented the petitioner from carrying out its business, despite the fact that Central Pollution Control Board has duly certified about the emissions from the factory concerned to be much below the permissible standard of emission of 25 mg per annum. Moreover, the NGT is seized with the issue and no stay order has been passed by the tribunal. Despite the same, the petitioner firm is not being able to function due to hindrance caused by the protesters who are in fact camping in and around the factory site. My Lords, paragraph 6, the Honorable Court says, considering the above submissions and having regard to the fact that complaint has been lodged, before the District Superintendent of Police, Pasighat, and also in view of what was observed in the earlier order of this court, learned additional advocates shall obtain complete instructions as to what steps have been taken by the district authorities on the grievance projected by the petitioner. Let the matter be listed again on 23rd of December. An action taken report be submitted by
So
district.
there is instruction.
Please,
Yes,
madam.
sir. We have received instruction, Your Lordship, from Superintendent of Police.
Okay.
Case already been registered, Your Lordship. And Your Lordship, we need to file counter affidavit, Your Lordship, in this regard.
My lords, the action taken report has not been filed, my lords.
So
Yes,
action taken report is there. Let them file in affidavit form.
Yes.
Your lordship. My
Okay.
lords, they are sitting and squatting on the road and they're not permitting ingress and egress to my site, your lordships, for last 3 months. 2 orders have been passed, your lordships, and they're saying only an FIR is registered. Now, my lords, what action have they taken? They have not yet mentioned. Have they tried to remove the encroachers, my lords, from the site?
Registered as Ruxin PS case numbers. What is this? PSGD into. Whether case registered?
Oh, yes, Your Lordship. We'll file affidavit, Your Lordship.
Okay.
Something left. Hey, Sangeeta Pradeep.
Okay. Hard miss.
Lordships, I'm Guinea Jetli.
G. Jetli Rabtre, Land Counsel for the petitioner. Assisted by local counsel Mr. Payang, na?
Yes, Lordship.
Land Counsel for the petitioner. G. Jetli, huh? Through RBC, huh? Assisted by Mr. Payang, a local counsel. I've also had Ms. Pango, then a government advocate who submits that in compliance of who submits that. Have you seen the case has been registered?
No, yeah, so I have only got this instruction, Your Lordship.
Okay. The submits that she had just received the instruction and will be filing affidavit. Okay. Mr. S. Irang, Land Counsel. You have not yet filed, but not listed. You file it first. Okay. It's not. It is not with. Okay. Some is that the. Who are you? You said villager. Appearing on with some is that the villagers of which village?
Industrial road, central pollution affected people's borders.
Of the industrial roads. Which village you said?
Affected village of that area.
Affected village. Some is that affected villagers of the area has filed interlocutory application for their implement in the present writ petition. However, the same has not been listed. Staff, huh? Para. And in view of the above, let this matter be listed after the ensuing winter break. Stop. Para. Notice was issued.
Please, Your Lordship. Notice was issued at the first hearing and accepted by them.
By which order it was issued?
Your Lordships, this is the first order, 10th of November. Paragraph 5. On the interim also, my lords.
Okay.
So specifically because of the Honorable
Okay.
Supreme Court's direction, Your Lordships,
Then,
that
okay, in Pangus, that one, obtain instruction and they will, she will be filing affidavit in for and on behalf, affidavit on behalf of respondent, all the respondent.
Or respondent, Your Lordship.
Okay, affidavit on behalf of the state respondent, for which she requires some time, stop. After that, then Iran, okay. In view of the above, and as prayed for, list this matter after 3 weeks. We'll say 3 weeks, okay.
Oblige, Your Lordship.
Along with the IA.
my lords, may I
You give the
request
number.
for a date in the matter, Your Lordships, because I will have to travel for
After
this.
3 weeks.
Okay, then in that case, in view of the above, and as requested by the Rani Council for the parties, let this matter be listed on. When do you want, you said?
7th, Your Lordships, if my lords is inclined.
7 to
When?
7th of January, my lords.
7th.
7th of January, Your Lordships.
Can you file?
No, Your Lordship.
Then,
Petition
okay.
is there.
19th.
Okay, 19.
19th
9th.
of January. Okay.
19, okay.
Okay.
Oblige, Your Lordship. Item number 2.
I'm obliged, Lordships.
May Your Lordship. Your Lordship, this writ petition is related to the illegal land occupied matter, Your Lordship. So here, Your Lordship, in this writ petition, Your Lordship, the petitioner forefather was the occupation of 100 acres of private land.
Just a minute. Whether a notice was issued here in this case?
No, my
Your-
here, my lord, I was supposed to get instruction, my lord.
Okay, what is your instruction then?
It's instruction that my lord, Secretary Land Management has not received any representation till date, my lord. That's why, my lord, it was to dispose of, my lord.
You were asked to obtain instruction with regard whether the secretary has received any
Yeah,
representation.
representation, yes, my lord.
Just a minute, huh?
And the representation is in page number 37, my lord, in the writ
So
petition.
that representation you have not received.
No, my lord.
And then the petitioner says that the representation was submitted before the authority.
Yes, my lord, and it was received
And
also, my lord.
praying for dispose of the.
Yes, my lord, that
Okay,
representation.
since you have not received, it cannot be.
Yes, my lord.
So then what to do? Instruction says that you have not submitted representation before the authority.
But it was received, my lord. So I think it is in the office only, my lord.
It is in the office.
Yes, my lord. Maybe my secretary has not received it yet, my lord. Till then, my secretary may not have received, my lord.
Okay.
So it was received on 11/7/25, my lord. So may I pray that this matter may be disposed of, my lord?
Dispose of with the
Yes.
direction to?
If the representation is received by the
Your
secretary.
prayer is to dispose of the representation
Yes, my lord.
submitted
One
by
prayer,
you.
one of the prayer, my lord.
One of the prayer.
Yes,
What is the other prayer?
Finally. Five. For directions to the deponent authority to verify the present status, Your Worship, of the land and verify the claim of the petitioners.
So there are a lot of prayer. Return the lane of the petitioner measuring so and so. For setting is an allotment order also. Probably you may have to file affidavit, it appears.
Yes, my lord, I'll file, my lord.
Hmm?
I'll file
Okay,
affidavit.
hard miss?
I'm sorry, Your Lordship.
Learned counsel for the petitioner. Also had Ms. Wang Mo, learned counsel appearing on behalf of all the respondent.
2, 3, 4, and 8, my lord.
Okay, for the state respondent number 2, 3, 4, and 8.
8.
Okay, Kato is appearing. Okay, then first Mr. Kato, huh?
Malad, I am for
Then
respondent number
DSGI for
one.
respondent number 1.
And 5, 6,
5,
and 7 also. Malad.
6, and 7. Okay. Issue notice. Just a minute. Huh? But in the you made a prayer that you have. It appears that you have a limited prayer to dispose of the representation. But then in the main prayer, there is a lot of prayer.
Yes, my lord. Yes.
So there is a contradictory. So in that case, so this issuance of notice would be better. Okay. Mm. Okay. Then Ms. Wang Mo, Learning Government Advocate, Sami State. There are two representations.
Yes, my lord. One is legal notice, my lord. Reply to legal notice, my lord.
Okay. She has an instruction that the respondent authority has received the legal notice served by the counsel for the petitioner. Sorry, the petitioner on behalf of the petitioner, and a representation. Representation dated. Does it have any date?
Yes, my lord. 10/7/25, my lord.
10/7/2025. However, the copy has not been made available to her. Therefore, she prays for some time to obtain the copy and also and to file in affidavit form. Okay.
Yes, sir.
Obtain the copies along with the necessary instruction and to file affidavit, for which she prays for some time. The prayer is allowed. This matter after 3 weeks.
My lord, kindly place this matter for 21st of the January.
Okay, then and as prayed for and as requested by the Learning Council for the parties, let this matter be listed on 21st.
Yes, 21st
Okay, January.
of lights.
Item number 3.
Mayor Lordship, kindly the matter may be taken after break since the leading counsel is currently engaged in court 4.
Okay. Okay.
Oblige.
Item number 4.
Mayor Lordship.
Yes.
Item number 4, Lordship, here the simple questions before this honorable court is, Lordship, here the petitioner is was appointed as a Wakalasi Majdur in the year 1995, Lordship.
I think before starting, we may have to. Then we'll take up this matter. Continue at 2.
Lordship, this only a notice be issued, Your Lordship.
Okay,
Since I have
notice.
not asked for any upgrade.
Okay,
any,
Mr. B. Jamo, and counsel for the petitioner.
Yes, ma'am.
Also, Miss
1 to 7, my lord.
Wang Mo for The government advocate for state respondent number 1 to
7, my lord. All, my lord.
1 to 7.
Yes, my lord.
All.
Yes, my
Okay.
lord.
All the respondent number 1 to 7 staff. Huh? Issue notice. Returnable by 4 weeks. Staff. Since Ms. Wangmo appear and accepted notice on behalf of all the respondents, no formal notice required to be sent. Staff. However, the petitioner shall furnish requisite extra copies to the learned counsel for the learned government advocate within 3 days from today. Staff. List this matter after 4 weeks.
Yes, Lordship.
Same.
Obliged Lordship, the item number 5 also same.
Same.
5 also?
Yes.
Okay, 5 also similar order.
Similar.
Yes,
Okay,
obliged.
the rest will take up at 2. Hmm. Yes.
Pass over matter item number 3.
My Lordship.
Yeah.
Lordship, I'm impugned by the rejection list, page number 77 to 89. Lordship.
What rejection?
Basically, Lordship, the matter pertains to the payment of compensation, Lordship.
Okay.
Lordship, what happens earlier occasion, Lordship, the Deputy Commissioner CME district has issued a one notice. That notification was challenged before this honorable court by the different petitioners, and that has been set aside and quashed, Lordship, and allowed that the petitioner therein to get the benefit as right for Lordship. And now, Lord, this is a similar situated matter, Lordship. Now, there was a three rejection list. Rejection list 1, rejection list 2, and rejection list 3. 1 and 2 that they have succeeded by setting aside of the notification, earlier notification. Now, basically, Your Honor, this is a case entirely covered by WPC number 03 of 2023, page number 97 onwards.
Hmm.
Subsequent to this judgment, Lordship, page number 97.
Hmm.
Subsequent to this judgment, Lordship, another WPC 393 of 2024, page number 151.
Okay. Hmm.
Here also the rejection list was challenged, Lordship. And now that, and this honorable court has allowed the petition, Lordship. And similar case, Lordship, page number 155 on Lordship. WPC 407 of 2024, Lordship. And operative percentage, Lordship, para 2, 3, six and 7. This both WPC 393 of 24 and 407 of 24 has allowed as a covered case of WPC 303 of 2022, Lordship. On same stretch of road, Lordship. This is the only grievance before this honorable court. The same rejection list prepared by the Deputy Commissioner be allowed the petitioner therein to allow to get the compensation amount, Lordship. Now, compensation has been already assessed and the amount has been deposited in the account of Deputy Commissioner and the LRS, Lordship.
Yes.
Lordship, at this stage, Lordship, since this is motion, Lordship, let notice go. Though, sir, he have shown the similar
Okay,
judgment.
you obtain instruction then, okay?
Yes, Lordship.
It's okay, I think.
Otherwise, Lordship,
No,
if
but
agrees,
still,
then
Lordship, notice has to go first, Lordship. So we don't know if they are, since they are already in the rejected list, Lordship.
Pardon, Mr. Indigo, Land Council for the petitioner. Also, pardon, Mr. Who is this? Who's come first?
Government.
Lordship, time for 1, 2, 4.
Miss Riba.
And for respondent number 5 and 6.
Lanet, additional government senior advocate for respondent number 1, 1,
1 to 4, Lordship.
1 to 4, and Mr. Tato, Lanet DSGI. For respondent
For
number
5 and 6.
5 and 6. Start of parish. We just obtain instruction if it covers, if it is a covered case, we can pass similar order. Okay.
Yes, Lordship. And then since they have already represented themselves, the pendency shall not be a bar for the Deputy Commissioner to dispose of their representation.
Okay.
This is Tato, Lordship, Spike 5.
The petitioner is agreed by the rejection list prepared by the Deputy Commissioner from serial number 1 to 126. Whose structure
1 to 126
are denied to be included in the list of compensation by citing that the structure is constructed in violation of public notice dated 29 and dated number SHY stroke LM dash 01 stroke 2019 stroke 220 dated 29/3/2021. It is submitted that in the similar the similar rejection list issued by the Deputy Commissioner has been challenged by the petitioner in WPC number 03/2024, which has been quashed by order dated 14/8/2024 and allow the beneficiary to avail the compensation. So by filing this petition, the petitioner seek passing the similar order as in the case of the seeking grant of similar relief as has been granted in WPC number 03/2024, comma, WPC number 393/2024, and WPC number 407/2025. Staff, issue notice. Any record need to be called for? No.
Lordship, I think the record is not necessary since
Okay.
this is entirely covered by the above.
Okay, since both, as Ms. Jiriba and an additional senior government advocate appear and has accepted notice on behalf of respondent number 1 to 4 and Mr. Ikato, Lani DSGI for respondent number 5 and 6. No formal notice required to be sent. However, the petitioner shall furnish requisite extra copies to the council appearing on behalf of the respondent within 2 days from today. Stop. List this matter after
4 weeks, Lordship.
4 weeks.
4 weeks.
Lordship, my
Tato, Lordship.
a small prayer, Lordship. The pendency of this writ petition, may not-
4 weeks. Stop.
I have already filed my representation
Pendency
on
of this writ petition shall not be barred.
page number
However, it is my
176.
Pendency of this writ petition shall not be barred on the respondents to consider. Where is
Page
the
176. 176 representation dated 10/11/2025.
you have mentioned here?
Yes, Lordship.
For the representation submitted by the petitioner dated
10/11/2025.
10/11/20. Is
25.
it in the prayer?
Yes, Lordship.
10/11/2025.
Yes, Lordship.
Page number
Page number 176, Lordship.
176.
Extra.
Good.
Basically.
10/11/2025 submitted by the petitioner before the deputy commissioner. It is the respondent, authority more particular, the respondent, DC is respondent number
3.
4.
Lordship, I have to confirm it.
DC is, yes, 4. No.
4.
Yes, Lord.
4.
No, district collector come, okay, respondent number 4, To dispose of the representation submitted by the petitioner, on date. Okay, list this matter after 4 weeks.
Obliged.
Deeply obliged.
Item number 6.
Am I audible, Miloj? Miloj, am I audible? Yes, may please, Miloj. Miloj, this is Miloj's writ petition, Miloj. I am, Miloj, aggrieved by the order passed by the estate officer, which is at page number 35, Miloj, annexure P7. But before coming to this order, Miloj, I must apprise this honorable court about the brief facts, Miloj. Miloj, in 2010, Miloj, I sought some financial assistance under the central sponsored scheme from the National Cooperative Development Corporation, and thereafter, Miloj, they paid me all the installments, but last installment they did not pay, Miloj, and thereafter my project suffered. So I have annexed all these representation in annexure 4. I am not going into that, Miloj. I am just giving this brief fact. And thereafter, Miloj, when my project got suffered, they themselves went to debt recovery tribunal in Delhi. Miloj, with regard to the mortgage land which I had mortgaged to them when I had sought this financial assistance. So, Miloj, with regard to the same land, this impugned order has been passed that they want to demarcate it, which is now, Miloj, may kindly come to Annexure P7, page 35. My lords, it says,
Just
my
a
lord,
minute, just a minute.
may I proceed, my lords?
Just a minute, huh?
Please, my lords.
The petitioner, who is this petitioner?
My lords, petitioner is a cooperative industrial society, my lords, private limited company, which had started the bamboo project, and for this the petitioner had availed this, my lords, loan, which is financial assistance under the central
Loan from?
NCDC, National Cooperative Development Corporation.
Okay. Okay, then?
Then my lords, the National Cooperative did not pay all the installments, and the
Okay.
project suffered. So National Cooperative themselves went to the DRT, Debt Recovery Tribunal, and they without issuing notice of 13(4) under SARFAESI Act, they went to DRT. Now the
Who went to?
NCDC.
Who
my
went
lords,
to whom, you said?
NCDC, my lords, NCDC, National Cooperative Development Corporation, went to DRT.
Okay.
And now the state of Arunachal has issued this impugned order, which has nothing to do with the mortgage land. And why it is doing this, my lords? Without assigning any reason, they have issued this order, impugned order. My lords may see only two words in this order. One, they are saying
Where is the impugned order?
at page 35, my lords, annexure P7.
It's just a minute, huh? Okay, this regarding mortgage land.
This is regarding the mortgage land. Now they want to demarcate this land, and they have
Just
made
a
it.
minute. That's in here.
Just Ministry. Corporation.
Okay, DRT Delhi.
DRT Delhi, they have the corporation has filed the case, my lords, against me. But we have not been served all the copies and all. We have just learned the notice we have received. Annexure P6.
Any order passed? Okay.
Yes, my lords, I have annexed the last order at page, my lords, 34, annexure P6. If my lords may see page 34. Page 34. 34, sixth annexure of the petition, my lords.
Is the impugned order?
No, my lords. Impugned order is
page 34 is impugned order.
My lords, impugned order is at page 35, which is issued by the estate officer.
35.
Yes, my lords.
What is this 34?
34 is the my lords, order which was issued by the DRT. Debt Recovery Tribunal has issued the one order. So we have just annexed this, to show that the matter is sub judice before DRT. And now the estate officer of Arunachal
So page
Pradesh,
35 is the impugned order. Passed
Correct.
by whom?
passed by the estate officer, my lords. Estate officer, Sarbansi district, my lords. Sarbansiri, I may be
Subansiri district.
Subansiri district, my lords. I apologize for wrong pronunciation, lords. Subansiri. And this order also gives the reference, my lords, reference of the mortgaged land to NCDC with regard to defaulted cooperative society. Subsequently, my lords, I have made representations also to Commissioner.
You are agreed by this impugned order?
Yes, my lords.
What it says?
This order says, my lords, that this in a view to carry out demarcation with regard to the
in view to carrying out the demarcation of mortgaged lands to the National Cooperative Development Corporation of defaulted cooperative societies, the following officers/officials are hereby constituted for the said purpose. The team shall consist of first Shri Radhe Tatung, second Shri
Okay, list of default cooperative society.
and the first
And
one
then
this is primary.
first one is yours.
First one is mine, my lords.
Okay.
And they are
Then-
saying very categorically mortgage to NCDC.
It will be conducted on 18 November.
My lords,
18
they have
November.
they have not conducted as yet, my lords. It is still pending, my lords. But the point is, my lords, that
No idea.
my issue is, my lords, when
Yes.
May I proceed, my lords?
This was issued way back in 11 November.
It was issued on 11th November. Then on 19th November, I made the representation. I have made representation to both
17
the
November. Okay. You have submitted representation.
Yes, my lords. Annexure P8 is there, my lords. P8 and P9 at page 36 and page 40. My representations are there.
No.
Which,
Page 36 to 40 is your representation.
yes, my lords. To state
Whose representation?
my representation to the estate officer and the
Matrix
the
Primary
commissioner.
Industry Cooperative Society Limited 0.
Yes, my lords. My lords, there are only two issues for consideration, my lord. One is when the NCDC is already pursuing the matter for recovery, then should this order of this orders be issued by the state of Arunachal Pradesh or not?
No.
This is,
Who filed before the DRT?
my lords, the NCDC, the National Cooperative Development Corporation, has filed before DRT.
Okay, and then this impugned order was issued on whose insistence?
My lords, I have availed
On
loan
what
from-
basis this order was issued?
This basis is not given, my lords. This is very interesting. Without assigning any reason that why they want to demarcate this land, they have issued this order. Without assigning any reason, they just say that in order in a view to carry out this has been issued. In a view to carry out demarcation, following people will be doing this. They are saying this.
No, unless someone makes a complaint, how would they know that you are defaulter?
Exactly, Lordship. There
Yes.
must be some order or
Yes.
complaint.
So, my lords, let the
which have
notice
led to
be
this
issued.
which have led to this order, Lordship.
My lords,
That's why,
let
Lordship,
the
I
notice
pray
be
that
issued. Just a second, ma'am. My lords, let the notice be issued. Let them respond, and then, my lords, in case
Yes.
then I will try to
Just
satisfy.
tell me that. That can be done, Lordship. Only notice may be issued.
And for the time being, my lords, no coercive action should be taken, my lords.
No, Lordship, no interim, Lordship.
Then my lords may at least do one thing, my lords. My lords may issue notice and my lords may direct them to decide my representation simultaneously.
Mr.
Pankaj Sinha, my lords.
Pankaj
Sinha.
Pankaj Sinha, Land Council for the
Its petition itself doesn't have any clarity, Lordship.
petitioner.
My lords, my local council is there, my lords. I am from Delhi. Somebody is there, my lords.
Assisted by Miss
Vice Singhi.
Vice Singhi, Land Council for the petitioner. Huh? What is this prayer?
Lordship, I'll be for 1, 2, and 3.
Okay, just a minute. Huh?
My lord had put this query to me that how did they know about this? My lord, this is why
By
we are
this
here.
petition, the
My lord, only one submission.
the petitioner.
My lord, may I make a small submission, my lord? Small one.
Yeah.
My lord, this my lord
Yes,
had
what-
my lord had put this query, my lords, that why did they how
SL
did
the order dated. Just a minute. SL the
sorry.
order dated 11/11/2025. Whereby the respondent authority has directed. Whereby the respondent number, who has directed, who is this state officer is respondent number?
2.
Lordship.
Respondent
No.
2, 1 is commissioner and 2 is
The
state.
respondent number 2. The respondent number 2. Has been directed for conducting demarcation. No, directed for demarcation. Directed to carry out the identification and physical demarcation of the mortgage lane.
Of NCDC, Lordship.
Of
Mortgage to DCD.
Oh, no, not of, Lordship.
Hmm?
Mortgage lends to the,
It's a mortgage lane in.
yes.
And submit report. It's only direction to demarcate and submit report. Okay.
Yes, nothing.
Yes, my lords.
It is submitted that since the case is pending before the Debt Recovery Tribunal to Delhi, the respondent authority ought not to be sued. And ought not to have passed above other. Stop para. Issue notice, returnable by 4 weeks. Returnable within 4 weeks. Stop. Since Ms. Ribba, Learned Additional Senior Government Advocate, has appeared and accepted notice on behalf of the respondent number 1, 2, 3,
1, 2, and 3 only, Lordship.
1, 2, and 3. And who is for Deputy Director?
NCDC, this
Is a different council. They have a different council, Minister of Cooperation.
NCDC.
Okay, Government of India, okay. And Mr. Kato, you are for respondent number 5 only?
Yes, ma'am.
Then 4 probably? Who is 4?
4 is my lord,
NCDC is 4.
Yes,
My
government
lord,
of-
NCDC.
this my lord corporation.
They have their own standing council? No formal notice need be required to be sent to them. No one represent 4.
No, my lord.
No.
My lord, notice to go, my lord. This is a
The
confirmation, my lord.
petitioner shall take steps for notice upon the respondent number 4 by a speed post with registered within a week from today. Stop. List this matter after 4 weeks.
We may be furnished extra copies, Lordship.
My lord,
Okay.
2 small submissions
Okay.
before my lord.
The petitioner shall furnish
My lord, 1 submission, my
requisite
lord.
extra copy to the council appearing on behalf of the respondent number of the respective respondents during the course of the day. Stop. Para. In the meantime, it is made clear that the pendency of this writ petition shall not be barred. No, it's before the deputy commissioner,
Yes.
and then the order was passed by the estate officer. It's the same authority.
Same, Lordship.
It's not same, I think.
Same authority,
It's
my lord.
okay. Estate
Respondent 1 and 2
officer
are
is
there.
also
Yes,
deputy
my lord.
commissioner.
No, my lords. Respondent 1 is the deputy commissioner, and the state officer is the respondent 2, who is subordinate.
Estate officer of the office of the office. Okay.
0, Lord.
But then your representation is before the deputy commissioner.
I have made to both
Okay, in
of
the
them.
meantime- in the
State
meantime.
commissioner also, my lords.
Okay,
kindly
the
see
representation
case
also
56.
submitted before the estate officer also. In the meantime, there shall be no, the respondent shall not be barred from disposing of the representation submitted by the petitioner on 17/11/2025. Okay, list this matter after
Yes,
4
Lordship.
weeks.
That much on.
My lords,
Pendency shall not be.
my lords, one small submission, my lords, please. My lords, may I please make small
Yes.
submission? My lords had asked me one question, and that will clarify that why this writ petition is there. My lord had said that how did they know? How did they know that this is a mortgaged land? This shows, my lords, that NCDC and the district has some sort of they are on hands in gloves, and this is why I have filed stay application. That if the demarcation is not stayed,
Even hands in glove cannot work automatically.
No,
Has
no,
to
my
have
lord, so
some complaint or some representation,
that NCDC
some
must have
information
got
by
done, my lord.
in writing. That is why they have taken steps.
Because NCDC has done 2 things. One, on the one hand, they have filed debt recovery before debt recovery tribunal. On the other, they are getting it done through the state. So, my lords, I will be the sufferer. I first of all, I did not get all the installments. My project got suffered, and now they are doing this, my lords. So, my lords, may at least stay till the next.
What is the project, by the way? What is the project, by the way?
It's a bamboo project, my lords, bamboo processing project,
Okay.
in which, my lords, I was supposed to set up
It's not clear.
a very big
Intermittently, it
project
is-
having a lot of machines. So So my lords may kindly till the next date my lord may stay, and thereafter my lords may allow them, if my lords pleases to do so, let NCDC file their reply, thereafter my lords may proceed. Till
They'll
that
file
date,
reply. You
yes,
file,
till
you
next,
file
I pray.
affidavit in the meantime, okay? Okay.
They are the defaulter here.
so till next date my lords may
Item num-
kindly stay this, my lords.
Item number 7.
Grateful, my lords.
Yes.
I have for respondent number 1 to 3.
Okay. No one appears for the petitioner. You are appearing for the first time. Have you filed affidavit?
Yes, I have already filed.
Already filed. And you for?
I'm for 1 to 3. No.
1 to 3?
Yes.
Okay.
1 to 3 already filed.
1 to 3. How many respondents are there? Or Mr. K. Davi, Land Council for the respondent number 1, 2, 3 is present. And Sami said he has filed affidavit in opposition. No, respondent. Okay, there are other respondents also. 1, 2, 5, 6 also.
4 has been struck out.
Strike.
5 and 6 remain.
Then where is 3?
3 we have already filed.
Okay, 3 is also there. 4 struck out.
Yes,
Then 5 and 6 not yet.
not yet.
Okay. The office note dated 19/11/2025 reflect that the notice upon the respondent numbers 6 return unserved. In view of the above, the petitioner shall take fresh steps upon the respondent number 6 within a week. Respondent 6 by speed post with register within a week from today. List is matter after 4 weeks. Okay.
Item number 9.
As I have sought for, this matter can be disposed of with similar direction as passed by this the coordinate bench of this honorable court. This is the order.
Lordship, not today, because I have to go through Lordship, because last occasion, the petitioner said they will file rejoinder.
Yeah.
So
No, my lord, rejoinder is not required subsequent to this judgment, my lord.
today, so I need
You
to go through this.
You go through. He is based. Okay, this is similar.
Yes, my lord, similar, my lord.
Okay.
My lord, what happened?
You have a copy.
In fact, yesterday I furnished the copy to the.
You could have punished me yesterday.
No,
also.
it is not known. Senior friend is appearing in the matter.
Mr. Samkato, Land Council for the petition of
My lord, my friend, the matter will be disposed, fixed for tomorrow, my lord.
affidavit and reply. Okay.
My lord, here I differ.
He made the earlier were is it a pleaded case?
Yes, my lord.
Okay.
But it is not required as because the even affidavit in reply is also not required, my lord.
Hmm?
Affidavit in reply is not required subsequent to this development, my
That is
lord.
right. That is right.
Yes, ma'am.
When this order was passed?
On 19, my lord.
Okay.
1912.
Okay,
Yes.
1912.
Yes,
Okay.
ma'am.
Some is that in the similar case, this the coordinate bench of this court has passed judgment on 19/12/2025, whereby the relief was granted to the petitioner,
Yes, ma'am.
and therefore he seeks a similar other age in the case of the WPC number 25, AP 2025. Stop. Miss Vipa, learned additional senior government advocate, prays for some time to go through the same, Stop prayer allowed, this matter after a week.
My lord, may I pray
Immediately after?
for tomorrow, my lord?
No, Lordship.
Tomorrow would be
That
not,
cannot.
would not be possible. Immediately after the winter break, okay? Immediately after.
My lord, in fact, what if senior counsel was appearing, my lord, senior.
Tomorrow will fix less case. Probably they must have already prepared by now.
My lord,
Last date.
Let it be on 9.
Okay,
my
nice.
lord, 9th, I'll be, my lord, may I pray that, my lord, better maybe on 7th, my lord.
Okay, 7.
7th, I'm not here.
7 is.
8th.
I
Or
don't
fifth.
know.
Okay, 8 will do. 8.
Then let it be on 20th.
Okay, 9, my lord.
Because
Good target. 9.
I may not be remain present, but however, my lord, my brothers will be.
Okay. The- is
Obliged.
good.
My lord, other reason, nothing to be, my lord.
It's-
Why, my lord, they are taking, the senior advocate was appearing in the matter. It is not known, my lord, how this has been transferred, my lord. It is their own administrative work. However, my lord, had it been the case, then, my lord, I could have informed.
Okay. 9. Huh?
Anyway, my lord. Much obliged.
Obliged.
Item number 10.
May I please, Your Lordship? Your Lordship, in this matter, we need to take our, file our counter affidavit, Your Lordship.
Additional affidavit also filed. Okay.
Additional affidavit.
Mr. V. Jammulan, counsel for the petitioner is present. Ms. Sangeeta, the government advocate for the state respondent. Prays for. How much time you said?
3 weeks, Your Lordship.
For the 3 weeks time to file affidavit in opposition. The prayer is allowed. This matter after 3 weeks.
Obliged.
Lordship, the item number 11, the same matter, it's analogous matter, same order, similar order.
Similar order, huh? 11 also. Right.
Obliged.
Okay. Give look.
Item number 12.
May I finish, Your Lordship?
Yes.
Today is the date fixed for CD.
My lord, actually, this matter is firstly for the first time listed before this honorable court successively, because earlier, my lord, this matter was withdrawn. Since they have not added, my lord, 2 paragraph that whether there was case pending against the accused person or not. On that ground, they have withdrawn it and it was not placed. So now this matter, for the first time after refiling, this matter has been placed before your lordship.
Okay.
So my lord may call for the case diary, my lord.
Mr.
G. Fokon, Lordship.
Counsel for the petitioner. Also had Mr. Then additional PP for the state staff. Huh? This is
9.
an application filed under section 483 of BNSS, praying for grant of bail to the, who is seeking bail? Petitioner himself.
Wife.
Regular bail to the petitioner. You
Accused
said
to
that it's a to granting bail to the petitioner. You said petitioner is, you want bail for the wife.
For accused, Shariful Khan. The petitioner is the wife of accused.
See page 1, praying for granting regular bail to the petitioner. Then who is the petitioner?
Accused petitioner. For the time, type of will wrong, Lordship.
Even if we grant bail also, it will be to the petitioner only.
Accused not but in pair, Lordship. In pair.
Who has been arrested in connection with Bandardua PS case number 81 stroke 2025 under section 21C stroke 29 of NDPS Act. Staff. Okay. Issue notice all for the case diary. List this matter again. When?
My lord, maybe on my lord.
Call for a scan copy.
Yes, scan copy.
Scan copy of the case. Charge sheet not yet filed.
Not filed.
Okay, call for the scan copy of the case diary. Let's pray for list this matter again on
7th, my lord.
7th. Okay.
Item number 13.
This is same petition, Lordship. In in connection with another office case number 74/2020-25
Different
under section
PS case
7B,
number?
27
Okay.
and 29. Today is 53 days, Lordship.
Hmm?
Today is 53 days behind the bar, Lordship.
Okay.
And
Then it will be similar order, but then case number will change.
Yes, madam.
Bandurda PS case number 79, 74
74.
stroke 2025 under section 21B stroke 27 stroke 29 of NDPS Act. Huh? Rest will be similar, same.
Yes, madam. Same.
7th.
Lord, Your Lordship, this is 53 days today. Lordship, vacation is coming, and also Christmas is also coming. Please, on the length of detention of the accused person, this honorable court may grant
Then
bail to the
earliest is then? When is the earliest?
5th.
5th. You want this matter to be listed on 5th? First day, okay, 5th.
Obliged, Lordship.
Obliged, madam.
Item number 14.
Please, minutes.
Yes. Yes.
Yesterday, my lords, I called for the case diary.
Oh, yeah, here in this case. Have you received?
Yes, Lordship, I have received.
Okay, what is?
Lordship.
Yes, diary was called for.
Yes, Lordship. Lordship, this second page is the progress of investigation and the flag I have take, Lordship. That is.
Is there any other
movement of-
section other than the section which has been
No, Lordship.
started against accused?
Section Lordship 30 and 134B and 125 RPA only, Lordship.
134.
134B.
All the same, all the same. No, okay.
RP Act and 125 of RPA.
Okay, no new sections.
No, and 30 of Arms Act, that is only, Lordship. The three sections.
30 of Arms Act. Yes,
Yes,
okay. Place it. Please pass it.
And Lordship, 223 of BNS is there. That is already there. 223.
Okay. Custodial remand is no longer required now and is available, will be released. Okay. Well, pass order.
Only, Lordship, RP Act is non-bailable. Baki, rest is, Lordship.
Well, it's actually bailable offense. I have another judgment in case.
Yeah, which one? RP Act section? What is the maximum punishment? Oh. Section?
Section 1.
Up
to 3 years.
I
only.
believe my friend is
Very fast. CRPC.
As per definition, it is non-bailable, but the sentence is only 3 years, Lordship.
So that is why it's available.
Yes, Lordship.
Just a minute, huh? Just a minute. Up to 3 years.
Yes, Lordship.
Maximum is 3 years.
Yes, my lords. Up to 3 years. Therefore, bailable, my lords.
Okay, let us see. Let us see.
Lordship, it is non-bailable. That's why it is maintainable before the High Court. Otherwise, so it will not.
May I show this
If all are
judgment?
available, Lordship.
Just a minute.
If he's assigned him to, he will give us when
Where is, could you please, CRPC? It's not clear. Schedule 1. Where is the schedule 2? Oh, second schedule is here. Not here? Wait. IPC. It's fine only. Hmm. It's less than 3 years. Then it will be non-cog, it's available, any magistrate.
I will clarify this matter because it will have the impact on the other cases, my lord.
Yes.
The Supreme Court in the, my lord, the reported judgment is there, my lord, on 2022-10 SCC, my lord.
See the second schedule.
Yes, my lord, up to 3 years. Up to 3 years imprisonment, my lord. It has been held by the Supreme Court that the punishment can be extended to the 3 years. The court can give the maximum punishment of 3 years. So it will come under the Schedule 1, Part 2, my lord, Part 2 of cognizable and non-bailable one. My lord, this is the judgment, my lord. Here it has been discussed, my lord.
No, see please come to the Schedule 2, classification of offense. So it's if punishable with imprisonment for less than 3 years or with fine only, non-cognizable, bailable.
It says, my lord, less than 3 years. But so far as 125 of the RP Act is concerned, it says extend up to 3 years. Extend to 3 years.
So even up to 3 years also?
My lord, their discussion has been made by the Supreme Court in that context, my lord. This is the judgment, my lord. Para 10, my lord. Because the same section of 63 of the Copyright Act, there also, my lord,
if it goes to maximum, then it's not less than 3 years.
Yes, my lord.
You mean to say?
Classification, this part is there, my lord. If it is extend up to 3 years, the Supreme Court has decided if it is extend up to 3 years, then it will also come under that part, my lord, that cognizable and non-bailable one. My lord, Para 10, and my lord will see the Para 9. There is the same the provision prescribing providing the same classification, my lord. The Copyright Act, same punishment, extend up to minimum 6 months, extend up to 3 years, and that has been discussed by the Supreme Court in Para 10, my lord. My lord, see the 11 and 12 also, my lord. Then.
Copy.
I have no data. Yeah.
No, it offense start with the imprisonment for 3 years and onwards. 3 years and onwards.
Yes, my lord, that part has been discussed. My lord, that is very clear. 3 and onward. If it is extended up to 3 years, then
Here is the case where it's a maximum is 3 years.
yes, my lord, there it has been discussed. If imprisonment is up to 3 years, then the court can, my lord, can convict the accused for 3 years also. So it will come under that category.
Where the offense is punishable for imprisonment for less than 3 years. Offense can be said to be non-cognizable. Where the offense is punishable for imprisonment for less than 3 years.
Yes.
Or with fine only.
Yes.
An offense can be said to be non-cognizable.
Yes, my lord.
In view of the above clear position of law.
Yes, my lord. Okay.
Whether non-counsel appearing for. Yeah.
My lord will see that provision also, the 63. It was provided in Para 9, my lord. There also the punishment is minimum is 6 months and extend up to 3 years. There Supreme Court has held it's a cognizable and non-bailable. So the same will cover this case also.
Para 9.
Yes, 9, my lord, para 9, my lord, the provision has been provided, the classification for that offense, my lord. There, lordship will
Yes, no,
find.
yes, non-cognizable, bailable, any magistrate.
Yes, and my lord will see the 8, para 8 also, my lord, for section 63 of the Copyright Act. The punishment is, minimum is 6 months, and it will extend up to 3 years.
No, here, there is a minimum.
Yes, my lord,
Yeah.
6 months is the minimum.
But here is the case, probably minimum is not.
No, my lord, minimum
No, just
extend up to 3 years. We have to see that much.
extend has to be seen.
Yes, my lord. My lord, may kindly see that
The right.
provision.
So here they mention less than or not saying up to. That is why.
Yes, madam. Extend up to that is why, madam, for up to 3 years, there is no clear classification. So, the Supreme
Malaj,
Court
there
has said
is.
that
In fact, there is. Malaj, there is a Ranchi High Court judgment. If I may be permitted to circulate that judgment for your lordship's consideration, exactly deals on the 125 preposition. Malaj, this is the Ranchi High Court judgment. The petitioner is apprehending, this was a case of an anticipatory bail, was apprehending arrest in connection with cases registered under section so-and-so of IPC, section 123, 125, 126, and 127A of the Representations of People Act. 125 is specifically captured here, my lords, now, and has prayed for grant of an anticipatory bail. During the course of argument, this court has put a question to the as to which section is non-bailable, as admittedly section 171 FH is bailable. Learned counsel for the petitioner submitted that for the offense under section 125 of Representation of People Act, the maximum punishment is 3 years or with fine or with both is non-bailable. That's the submission made. Learned APP in that case, my lord, submits otherwise. Submits that the alleged offense are bailable in nature as punishment under section 125 of Representations of People Act is up to 3 years, whereas the classification of offense against other laws in first schedule of CRPC, item number 3,
says that the offense punishable with imprisonment for 3 years and
upwards being the keyword, my lord. But not more than several years are non-bailable. So, and upwards is the keyword here, my lords. 3 or more. In view of the above, the anticipatory bail was not found not maintainable because this is being a bailable offense directly on the preposition, my lords.
So 3 years and upward is non-bailable.
My lord.
What is the normal understanding?
My lord,
And as per the schedule
my lord, I will
also.
just read out. My brother will also appreciate that. My lord, the punishment, your lordship, wherein the Supreme Court is dealing with this offense, there the punishment was shall be punishable with imprisonment for a term which shall not be less than 6 months. 6 months we have got nothing to do, my lord.
Yes,
CRPC
nothing.
doesn't provide, but which may extend to 3 years and with fine, which shall not be less than 50,000 rupees. Now here says is extend up to 3 years. Extend to 3 years, my lord. It doesn't say minimum shall be 3 years. Extend to 3 years. Now, my lord, the Supreme Court here has discussed thus for the offense under section 63 of the Copyright Act, the punishment provided is imprisonment for a term shall not less than 6 months, but which may extend to 3 years and with fine. Therefore, the maximum punishment which can be imposed would be 3 years. Therefore, the learned magistrate may sentence the accused for a period of 3 years also.
That can be. Oh.
In
Sentence
that
can
view
be.
of the matter, considering part 2 of part schedule of CRPC, if the offence is punishable with imprisonment for 3 years and onward, but not more than 7 years, the offence is cognizable only in such case where the offence is punishable for imprisonment for less than 3 years or with fine only, the offence can be said to be non-cognizable, so and so. Now, Your Lordship, the operating main part 12. In view of the above discussion and for the reason stated above, it is observed and held that the offence 63 of the copyright is a cognizable and non-bailable matter. Supreme Court held that if it is, even if it extend to 3 years, the maximum punishment what magistrate can award is 3 years. So it will fall under that category, my lord.
See,
Otherwise, my lord, it
this,
would have
this was, this is 2016.
But this is a
16.
High Court judgment, my lord. It's a Supreme Court.
Yes, yes. Kindly see that one. See, the interpretation is up to 3 years. And then up to 3 years, if it goes 3 years, then it is.
That's correct, Milad. 3 and upward will be non-bailable and cognizable.
No.
My lord, then this.
So now,
This is
now
16.
see, the line is less than 3 years. You are talking about the less than 3 years.
Yes.
But here is the case, he can be punished up to 3 years.
3 years. 3 years also can be punished.
So then 3 years and upwards will be non-bailable again.
Yes, my lord.
What the Supreme Court, the
Yes, Supreme Court. This is what
Because
Supreme
I
Court
don't have
says.
the
Yeah,
question.
you just see.
If you can just airdrop it to me, I'll
Okay.
just read it. My understanding, Malaz, has always been, I'll just say one more judgment of Arnesh Kumar. In fact, Malaz, the Supreme Court has gone further and said even up to a provision where 7 years is provided for, you will not make a mechanical arrest.
He has not been arrested, first of all.
There is no dispute that investigation, the seizure is complete. This person has cooperated. He has to be released on bail. There is no dispute as to that proposition, at least insofar as I am able to understand. Malaj will have para 11, page 11. Give them a copy.
You get the printed copy of that.
Yes, my lord. I will airdrop him.
Para?
Copy. Malaj, para 11 at page 11.
And Arnesh Kumar, we have, my lord. Arnesh Kumar is very much clear, my lord.
Yes.
Arnesh Kumar Malaj says,
Para 11, page 11.
page 11, para 11. I'm actually referring to para 12. I'll just give the directions that have been there in 11.
Yes.
Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and the magistrate do not authorize detention casually and mechanically. In order to ensure that we have, in order to ensure what we have observed above, we give the following directions. All state governments to instruct its police officers not to automatically arrest when a case under section 498A of IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down above following from section 41 of CRPC. Then all police officers be provided with checklists containing specified subclauses of section so and so. The police officer shall forward the checklist duly filled in, furnish the reasons and materials which necessitated the arrest while forwarding the production of accused before the magistrate and for further detention. None of this has been done. Now, my lords, will come to para 12. That's the important aspect. We hasten to add that the directions aforesaid shall not only apply to cases of section 498A of IPC or section 4 of Diary Provision Act, that is the case in hand, but also to cases where offences is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years whether with or without the fine. So therefore, there was no reason, even now, let us assume the worst for myself, even if this falls under the second category, which it does not, my lords. Even in those circumstances, I ought to have been given a notice to produce myself before the concerned officer, which has not been done. Now, there is another fallback argument, my lords. Will see the grounds of arrest that have been given to me. That's in your lordship's case file. Yeah. Malaz has annexure B at page 34. That's the arrest memo.
Petition the
Whether the ground of arrest has been explained, given separately.
That is what I was saying. I will complete my submission, please. Page 35 is where the grounds of arrest are stated. Please see, these are checklist points.
So that is why I'm asking.
He's not allowing me to submit my lord.
No, my friend. What I was just pointing out at 35, your lordships will observe, these are checklist point pre-printed. There is no specific ground of arrest otherwise provided, not even a courtesy taken.
This is region. So I'm asking if the ground.
Reasons for ground of arrest, not even a tick mark, my lords, which ground of arrest is applicable to me in this.
The ground of arrest has been explained separately.
My lord, the ground in substance will suffice, my lord. This is what in Darshan case it was held, my lord, after Bihan also. And it has been, my lord, further it was later on discussed in the Mihir case also, my lord. Here, my lord, whether the tick mark has to be put there or not, my lord, from which instruction they are saying the tick mark has to be done in all these things. There is nothing is there in the Annexure B 34, it says which ground is applicable, for that only the tick mark should be made. From where this is coming, my lord. Here, in arrest checklist, my lord, the ground of arrest, your lordship will find your name is mentioned in FIR and corroborated by evidence. Investigation reveal your active presence, role in crime. Evidence suggests your involvement in criminal conspiracy to commit the crime. Digital so and so. You were apprehended in the act of shortly after. Stolen implementing material recovered from your possession. Your arrest is necessary. Your lordship, the gun was recovered from his possession. Although there is a license, but MCC was there. But your lordship will find in the second page 36, my lord. I have been informed the offense for which I have been arrested in cognizable and non-bailable in nature. I have also been informed for my legal rights to apply for bail before the competent court of law. The ground of my arrest along with the nature of the allegation have been clearly explained to me in language I understand. Further, the fact of my arrest and its ground have been duly communicated to my relative friend whose details have been recorded above me. Arrest signature, my lord. What is this, my lord?
There is a certificate and you have acknowledged it appears.
He put the signature. If signature was not there, then presumption is obviously in here their favor, my lord. He put the signature, and this person is aware that he has been arrested relating to, my lord, the section has been given. Later on, my lord, whatever the script is written, he can read, he can definitely go through it by, he understand English also, my lord. And everything has been, my lord, explained to him. And then later he put the signature, and now he is saying ground of arrest has not been communicated to me. The ground in substance has already been, my lord, complied or already been communicated, my lord. This is not a fit case for releasing the accused on bail, maybe on other aspect, my lord. But ground of arrest has been duly complied with by the police investigation agency. And so far as, my lord, this non-bail, if, my lord, the offense they are saying is non-bail, is bailable. If this is bailable offense, my lord, their judgment they are relying on. There also it says if it is bailable, then not maintainable, my lord. Because for 483, the offense has to be, my lord, non-bailable one.
Here is a case where
here is a case where I applied to trial court and
yes, my lord. Then trial court order they have to challenge, my lord.
They have to challenge
because article it's violate article 21, my lord.
Are you challenging the rejection?
Absolutely, my lords.
But in bail order, my
I've
lord,
impugned that order as well before, my lords. I've impugned that order before, my lords. My lords, I'll just come back to the grounds, my lords. Para 36 onwards, my lords, are the grounds in relation to
Rejection order is page 43, lordship.
Your lordships have seen that with us yesterday.
But we have come under 483 BNSS.
Yes, my lords. Well, insofar as 125 applicability is also concerned, there is an issue to that extent also. My lords will just read the FIR with me once. If at all, there is a single averment insofar as 125 is concerned, that's another substratum that your lordships will have to see. Please have the FIR with me, my lords, and also have the provision with me for once.
We'll have to see. So, printed copy of the judgment of the Supreme Court.
Millers will just for a moment come with me
Yes.
to page 27 and simultaneously also open 125 of Representations of People Act.
Page 27.
Page 27 of the application, my lords, which is before my lords. The first information report contents is what I wanted to show. And I also wanted to show the provision of 125. If even a bare minimum averment, substratum, anything at all, which can levy or penalize me for 125 exists in this FIR. My lords will just have 125 Representations of People's Act with me. Promoting enmity between classes in connection with election. Any person who in connection with the election under this act promotes or
Trial court. In the trial, it will be decided.
But
for the moment.
For the moment, my lords, I am saying that 125 is not applicable. No substratum, no underlying fact has been averred before the investigating officer.
The person has used the gun in the election day.
My lords, it requires me to say something of which brings out hatred language on any ground. Please see, any person who in connection with the election under this act promotes or attempts to promote on the ground of religion, race, caste, community or language, feelings, enmity or hatred between different classes of the citizens of India shall be punishable with so and so. Now, where is the averment? Where is that allegation at all in the FIR? Your lordships will please see. With respect to subject, I'm just reading the contents of the FIR. With respect to subject mentioned above, I have been informed you that during the surprise checking of so-and-so has been found inside the vehicle so-and-so who took the flying permit from undersigned for the whole day of Shri Charu Jaju so-and-so, village so-and-so. The details of the seizure can be found. Therefore, in the seizure moment, it is pertinent to mention that gun was loaded. Therefore, officer in charge may take the necessary action. Where is the averment that I have given? I have stated anything which brings out hatred. Where is the applicability of 125 in this?
As per the laws, fairly submitting lawsuit, 125 is not applicable because as the contents of the FIR lawsuit, it is not their lawsuit. 125 lawsuit that the definition of 125 is not attracted in the FIR. That's why I was not pressing the 125 because the ingredient was not there in the FIR lawsuit.
So then the rest are bailable.
Lawsuit. As per the case that the lawsuit, as per lawsuit public prosecutor, I'm fairly submitting. I'm not the in the view of lawsuit, I'm submitting that. I'm just submitting the fairly what is contained in the case study lawsuit. It is their lawsuit that
What the case there says
lawsuit
regarding
recover from him. Yes, lawsuit. 125 is not it's any kind of lawsuit. Statement is there for regarding 125 lawsuit.
In fact, the case diary also established that the seizure is complete. So there is no requirement of custodial interrogation. There's no requirement of custody any further.
Yesterday, Lordship, I spoken to IO also, Lordship, regarding the arrest, Lordship. He also, Lordship, stated that custody interrogation need not be required because only 2 more witnesses to be examined, Lordship. For that, Lordship, if any strict condition may be imposed, that would be do, Lordship.
Also recorded. Just okay. Mr.
Shubham Paliwal. Shubham Paliwal.
Okay. Your name is not there?
It's there in my Wakaltnama. It's there with the petition as well.
Shubham?
Nipun Shubham Paliwal. SHUBHAM PALIWAL.
Counsel for the petitioner. Also heard Miss Lakshmi, then additional PP for the state. This application under section 483 BNSS 2023 has been filed by the petitioner praying for release of the accused who has been arrested in connection with filing PS case number 22/2025 under section 223 of BNSS, BNS 2023, read with section 30 of Arms Act 1959 and section 134 B stroke 125 of Representation of the People Act 1951. What is 134? You said 34B?
134B is prohibition of going armed or to a or near to a polling station. That is up to 2 years.
Okay. Stop. Para. It is submitted that the offense registered against the accused are all, according to you, all bailable.
Yes, please.
All bailable offense. However, the learned Chief Judicial Magistrate by an order dated 19/12/2025 has rejected the bail application moved by the petitioner for release of the accused. What is the ground for rejection?
Well, it's the investigation being at nascent stage.
On the ground that the investigation of the case is at the nascent stage. Para. The land council for the petitioner some stat. The person accused of the bailable offense is entitled to be released on bail pending his trial. Relying on the decision of the decision of the Supreme Court decided in Vaman Narayan Ghia versus State of Rajasthan, reported in 2009 to SEC 281, where it is held that in case of bailable offense, a police officer has no discretion to refuse bail if the accused is prepared to furnish surety. Stop. The magistrate gets jurisdiction to grant bail during the course of investigation when the accused is produced before him. Stop. In bailable offense, there is no question of discretion for granting bail. The only choice for the court is as between taking a simple recognizance of the principal offender or demanding security with surety. The Lani Council for the petitioner submits that the accused is ready to furnish bail. And to abide by any terms and conditions to be imposed for his release. Stop there. Miss El Hage, Lani Edison PP. referring to the status report submits that fairly submits that the investigation of the case has almost been completed. And on instruction, she further submits that since the examination of the most of the witnesses, including the accused, has been completed, the further custodial interrogation of the accused is no longer required. However, she submits that the IO says that the accused should not threaten or coerce the
The
witness.
terms and condition, Lordship, may be
Okay, however-
imposed, Lordship.
In case of granting bail, however, she submits that in case of granting bail, a strict condition may be imposed upon the accused. Stop. Okay, the last part I'll. Okay, in view of the above. And as the in view of the submission made by the council for the parties, Rama. This court is of the view that in the instant case, as the investigation of the as the weapons stated to have been carried by the accused has already been seized, and the investigation of the case has already almost been completed. The custodial interrogation of the accused is reflected in the status report may not be required. Accordingly, this bail application is allowed. The accused is directed to be released on bail on execution of a bail bond of rupees 50,000 with two surety of like amount to the satisfaction of the arresting authority with the subject to the following condition, then the normal condition, okay, that he shall cooperate and appear before the eye of the case as in when called for, that he shall not directly or indirectly influence the witness in any manner, that he shall not leave the jurisdictional court without the prior permission of the eye of the case, prior information to the eye of the case. With the above, this bail application stands allowed and disposed of.
Okay.
Great. Let's maybe provided with dusty copy of this. We can maybe be provided with the dusty copy.
You can obtain,
So grateful.
download and can obtain.
So grateful. my lords.
Item number 15.
Well, the IA is relating to perjury.
IA is relating to
Perjury, my lord.
Hmm?
Perjury.
perjury.
For giving, yes, my lord, for giving false evidence before the court. It is punishable offense under section 229 BNS.
IA is for what?
This is my lord, for initiation of prosecution against.
Okay, initiation of.
Yes, my lord.
Against the.
Against the respondent, my lord.
Okay.
They
Taking
are.
direction.
Yes, my lord. They have committed the offense of perjury, punishable under section 229 BNS. And what had happened in this case? The Assam rifle occupied.
Just a minute, huh? This is, what is the main case for?
Main case is for payment of compensation, my lord,
Payment of compensation.
for acquisition of land.
Acquisition of land.
Yes, my lord.
And then this IA is for?
For perjury. Perjury means for punishment for giving false evidence before the court.
Before the court.
Yes,
Before this court.
before this court. They
Okay.
file an affidavit, my lord.
They have filed, you have.
They have
In the main, my lord, in the main case, they are seeking basically for the payment of compensation, my lord.
Okay.
In that, my lord, the main petition, my lord, we file affidavit, maybe my lord stating that some other, my lord, the factual background, which is not, my lord, it at all related to the other aspect, my lord. Then this IA has been filed for the prosecutions and for the offense of the perjury, my lord.
This
Now,
is taken up along with this. Along
yes,
with the
my
main.
lord. Now, my lord, yes, my lord. Now, my lord, the pleadings are completed. Matter can be, my lord, fixed for hearing, my lord.
My lord,
We have also,
Has it been admitted?
no, not yet, my lord.
my
Who is
lord,
the root then?
Yes.
Admit it.
I
Matter may be
may be
admitted.
disposed of, my lord. I may be disposed of.
We'll dispose of along with the main.
Yes,
case. Because
this
it-
is connected to the main
Yes,
case.
yes.
Matter,
Which they have already filed. Well, or you want this matter to be listed for admission hearing?
Admission hearing, my lord.
Okay.
But the issue is very limited actually regarding non-payment of compensation.
Okay.
In the year 2019, acquisition process started and fund was sanctioned in 2021. And it has not yet been paid to the petitioner.
Who is supposed to pay?
ITBP, actually ITBP, they have taken the land,
Okay.
but acquisition process was conducted by the Deputy Commissioner Dapur region.
Okay, on behalf of ITBP.
And they
Acquired?
acquired by the Deputy Commissioner for the ITBP. my lord.
ITBP. And
Yes.
then your name is there as a land owner?
Yes, my lord. I have given no
You are
objection
entitled.
certificate.
Okay. How many of you are there?
Only one, my lord.
Okay, only one.
Only one.
Land already acquired?
Acquired,
Compensation not yet paid?
not paid.
And
Fund sanctioned. my
perjury
lord.
case is against whom?
My lord, in IA,
Yes.
there are few officers, my lord.
Okay. Of the respondents.
Respondents.
Okay, we'll take up along it. Okay,
Yes,
let us see.
yes,
Entire matter will be heard.
yes,
Okay. Since the parties are duly heard Mr. Iskoyang, Land Council for the petition, applicant with petitioner, staff also heard Mr. Kato, Land here privately.
no, my lord. For ITBP, my lord,
Okay,
Union of
okay,
India,
Land DSTI
1, 2, 3, my lord.
for respondent number 1, 2, 3,
Yes,
and
ma'am.
Ms. Sangeeta 4. Respondent 1, 2, 4 and 5. 4 and 5. Have you filed affidavit?
Yes.
Okay.
The main case.
And okay, since the parties are duly represented and the pleadings complete, let this matter be listed for admission hearing.
Yes,
after
madam. After vacation, madam.
after vacation. Okay.
Oblige, madam.
Development.
Item number 18.
Main case. Item
18.
Okay. Yes.
Lordship, I am for respondent number 2, Lordship. I had filed reply, Lordship.
You are for respondent number
2.
2. And, sorry. Okay.
Your Honor, I'm petitioner
Yes, okay.
on behalf of Takam Smith.
Affidavit in opposition file on behalf of the respondent. You have already filed affidavit.
Yes, yes, Lordship.
Okay. What do you want now?
Fixed for hearing, Your Honor.
For hearing?
Yes.
Lordship, respondent number 1 is RTI Commissioner, Lordship.
One has filed affidavit.
I'm not aware.
Filed. Then it cannot be listed for hearing. It will be listed for. Let the respondent number 1 also file affidavit. Affidavit required or not required?
Your Honor, I'm not versed because I'm not the counsel
Okay.
on this matter.
Then let the respondent number 1 also file affidavit.
Okay.
Thereafter will be fixed for hearing. Okay.
Okay.
Yes, Lordship.
Okay. Hard Miss
M. Jarang.
Land counsel for the petitioner. Also hard Mr.
HT Tara, Lordship.
Titara, Land counsel appearing on behalf of the respondent 2, who submits that he has filed affidavit in opposition.
And Your Honor, there is interim,
Stop.
which may continue.
The respondent number 1, who represent respondent number 1?
R. Soikia, Lordship.
Okay, is yet to file. The office note reflect that the respondent number 1 is yet to file affidavit. In view of the above, let this matter be listed after 3 weeks. Okay. The interim order passed earlier shall continue till the next date of listing.
Much
okay.
To be Lordship.
Item number 19.
Lordship, may I draw your kind attention
Yes.
to the earlier order dated 17/12/2025, for which I pray for exhibition of documents.
Documents can be exhibited.
My lord, with comparing with the original, now to today, no time.
How many documents are there?
Only two, it's only, my lord. 12 documents, my lord.
12.
12, yeah.
Okay. Have you brought it in typed out one? I think probably on that day I have instructed. I have directed to bring out an typed out copy, your exhibit number, the name of the documents.
Yeah, my lord. I have.
You prepare index serial number.
My lord, yeah.
Name of the documents.
Yeah.
Exhibit number.
Yeah, my
have
lord.
you prepared?
Prepared, my lord.
Please. Have you compiled the documents?
My lord.
Have you compiled?
Yeah, my lord.
Okay. Just show it to him once.
Were not compiled, I think.
Have you compiled the document? You have to compile the document, bind it, and then we have to mark there.
Yeah, we have, then comparing with the original.
And then that will be compared with the original. And
Then only exhibition. So that, my lord, I have not separately compiled that one with my petition. I have
then
got,
who will compile?
Oh.
Your documents, list of documents. That will have, you have to compile it.
Let him make an index and.
You make an index. The serial number is fine. Nature, it's probably name of the documents.
My lord.
Okay. Exhibit number.
Yeah.
Okay, in the last column.
Yeah.
So these also probably you have to correct it. For the serial number is correct.
Correct.
Name of the documents. Exhibit number.
Exhibit.
And in the last, it should be remarked if there is any.
Yeah.
Okay.
Yeah.
Then with that, you accordingly you compile which one you mark as exhibit 1, A, B, C. You mark it. Will it be A, B, C, D or 1, 2, 3?
ABC, my lord.
It will be A, B, C, D.
In my petition, I have annex as a ABC.
Now, first I think it's A, B, C, D or 1, 2,
3, mark.
It is 1 to 3, it will be convenient.
Because what is the first, it should be 1, 2, 3, I think.
1 to 3.
Okay, 1 and 2. Okay, you compile this, you corrected this. Okay, list of document, list of document, stroke, exhibit.
My
Okay?
lord, my lord.
Serial number,
Yeah.
name of the document, exhibit number,
My lord.
and then remarks.
Yeah, my lord.
And then that will be your document. And then on the next, what we'll do, there must be some documents to be produced by the official witness also.
My lord.
Is that separate one?
No, no, that is no separate one. Already.
It is here.
Yeah, it is here, my lord.
It is here.
Yeah.
Okay, their document you have compiled here.
Yeah, my lord. Yeah.
Then you compile it properly and then let him compare on that day, next day, because before appearing here, you just furnish him once and then compare it. And then when it comes, we'll just dictate it.
Okay.
Okay. Compare, give him on the same day in the morning hour.
Yeah.
You give him the copy, let him compare, and if he agrees, then we'll mark it exhibit on the next day.
Yes. Yes.
When do you want?
5th, my lord, after vacation.
On 5th?
Yeah, my lord.
I have no idea.
5th, I think 5th is a holiday.
5th is not holiday. It's Tuesday, something like Tuesday.
6th is holiday.
So.
My lord, it will take some time, man.
No. It won't take much time if he is prepared.
Yeah, I am prepared, my lord. Otherwise, tomorrow also I am ready, my lord.
The other election petition is also fixed today only.
Yes, man. I can.
Then both will be fixed together. Okay. And let us fix it on 7.
7.
My lord,
6 is only one day because sorry,
my lord.
5th is only one day. Then there will be holiday on
Yes, man.
7.
Okay.
7.
What?
7, my lord.
Just a minute. 5th is okay only. 5th will not. We are not going to fix so many items, but then this election petition will be fixed on 5th.
Yeah.
Okay.
It will take not so much time, my lord.
Okay. Had Mr. Nelson Johnson, petitioner in person, also had Mr. Deore, Land Council for the opposite party number 1. Opposite party, huh? It's a sole opposite,
Yes.
sole respondent. Huh?
Not sole respondent and the respondent number 1. There are other.
Okay, so respondent number 1, huh? What is this IA for? What is this IA for? What is order?
The I is for recalling, calling up, summoning up with.
Witness and this documents, my lord.
Okay. Next, para, huh? Mr. Nelson Johnson, petitioner in person, raised for some time to compile the exhibit.
He took Christmas and Christmas was
Staff, to which Mr. Deore has no objection. Staff, as requested by both the Nana Council for the parties, list his matter again on 5/1/2026 for exhibition of the documents by the election petitioner. Okay.
much obliged.
Item number 22.
Yes.
In item number 22, Lordship, in item number 22, I have filed an IA for adjournment, my lord, under order 7. My lord, what happened in this matter, my lord? Applicant, my lord, the applicant, the number sole respondent, he engaged Mr. P.K. Tiwari, Lanet Senior Counsel. My lord, he is not well.
Okay.
So he is sick some time, my lord,
Okay. In IA?
in IA. IA, this is for only for adjournment, my lord.
My lord,
Because it is
What is this
original
case about? What is this case about otherwise?
my lord, that's
my lord,
election
IA
matter.
321.
My lord,
IA number
this is the
321.
matter
this is
where,
election petition. Okay.
Election
yes,
petition.
where Your Lordship was pleased to pass an order on 16 for the exhibition of the documents. We have already filed the list of documents. We have also filed precise application stating the exhibit numbers. But on the last occasion, on 16th of this month, when the matter was to be taken up, there was a prayer by London friend Mr. Diori that he was not very keeping in good health because of the Panchayat election. So that Your Lordship was pleased to adjourn the matter and fix it today. But again, yesterday they have filed another application only on the ground that another senior counsel was engaged. Yesterday itself, when they filed an application seeking for 30 days time. And this has been done only to delay the matter, Lord. Therefore, my Lord,
No.
if Your Lordship is pleased,
Yes.
if Your Lordship is pleased, well, I can see the paucity of time so for today's concern. So the matter may kindly fix on 5th because everything is completed from our side.
Okay.
The only thing is that
We'll do.
5th,
My lord,
my
in
Lord,
this day,
and
Mr.
now
Lanet
only
Senior Counsel, he could not come. He will attend for virtually then.
No.
For
Fifth-
hearing.
on 5th, you be there.
I will be there.
It will be only exhibition only.
My
Exhibition
lord,
of the documents only.
I-
You just
the-
compare it same as
No,
what
my
you have directed in the.
there is a IA under order 6, rule 16.
Hmm.
That may be hard for us, my lord.
What is that?
That is for struck of the pleading, my lord. Some pleadings are there because 2 issues are dropped. That's why, my lord, Lanet Senior Counsel, he wants to argue.
my Lord, my humble
We
submission.
have already taken consent, my lord,
My
in
Lord,
advance.
so far this particular IA is
So
concerned
today, that's why we have filed this
under Order 6, Rule
IA
6,
for adjournment.
Order 6, Rule 16 and Rule 17. So far, Rule 16 concerned, they are saying for striking of pleadings on the basis of the dead 2 issues which was dropped on the prayer for the petition strike. But so far, Rule 17 is concerned, my Lord, if amendment is to be made, it is to be made by the party, an application. How can now they are filing an application so
My
that
lord,
we have to amend our
today is
election
not for
petition?
hearing of that IA,
No,
my lord.
no.
Today
So
I filed this
therefore,
adjournment
my humble
petition.
submission is
Let
even
the
the
matter may be
IA,
adjourned.
even the IA is only to delay the matter. The IA is only to delay the matter. We have given reply to
No,
the
my
IA
lord. We
also.
are not objecting anything, my lord. Right from the beginning, we are cooperating. We are not taking any time.
Therefore,
Everything
on
has
fifth-
been doing
on
on time.
fifth-
Mr. Singh, have you filed a affidavit
Yes, we have
for
filed.
objection in
Yes,
in IA?
yes, my lord.
You have
My
already
learned
filed.
all,
Okay, on the same day it will be heard.
and it can be heard on the same day, and even we can exhibit on the same day on 5th, my lord. 5th January
Okay,
2026.
Okay, then in the which one is listed first? IA 315, huh? Mr. Deori,
Yes, my lord.
learning counsel for the applicant submits that in the instant case, his senior Mr. Tiwari is appearing, will be appearing. However, he is not keeping well at the moment, due to which he could not appear, and therefore pray for adjournment of the. Have you filed adjournment?
Yes, my lord. Application number 321.
Okay, then this application 321, huh? IA, huh? Okay. In 321, huh? Mr. Deori, Land Counsel for the applicant. Para. This is an application filed under order 17, Rule 1 of the Code of Civil Procedure, seeking adjournment of the election petition for another date. So the prayer of the application has not been objected to by the Lanai Council appearing on behalf of the respondent on the condition. However, on the condition that same is being heard, the same is fixed on 5th for hearing. Okay. In view of the above, the application for this application is for adjournment is allowed and disposed of. Okay. Then in the main in view of the order pass in IA, then that will be in IA only, isn't it? Yes. IA 3 on 5, huh? In view of the order pass today in IA 321 AP 2025, the matter stand adjourned. The matter stand adjourned. Stop. List this matter as requested, list this matter on 5/1. Okay. And then in the main
case,
in the main had Mr. Singh, huh?
My lord.
This Singh, Lanai Council for the election petitioner. Also Mr. Deori, Lanai Council for the respondent number 1, appearing on behalf of the respondent number 1. Staff, huh? In view of the order pass today in C 321 AP 2025, the matter stand adjourned. Staff as requested, list this matter again on 5, along with the interlocutor, along with the IA 3315 AP 2025. Then list this matter again on 5, huh? Have we recorded earlier that it will be fixed for
Yes, my
the
lord.
exhibition?
Yes, my lord. On the earlier, on the date before 16th of 12. In fact,
In order
16
it was not recorded. 16/12.
The lordship in the order, it was not recorded for exhibition of the documents.
For exhibition of the document
Yes, so it may be recorded today, lords.
of the election petitioner. Okay. On that day, Mr. Singh, you come prepare with age. You said that a table. Okay.
My lord,
Serial
that-
number, name of the document, and an exhibit number. Okay.
Ma'am, there
And
has been
then,
we have already
on that day, kindly show it to the respondent for comparing. Okay, so that when it comes to the court, we'll straight away dictate, because he let him compare and then agree with and then found compare and found correct. Okay, so that way will so that it is expedited.
My lord.
Okay.
My lord,
Right.
a humble
On that day,
summation.
because since it will take time, on 5th, less case will be listed
My
in
lord.
form. Okay, because
My lord.
this will take time.
And
Okay.
a humble submission and no
very less
adjournment.
case.
My lord, my humble submission, no adjournment shall be allowed on any
There
other.
will be no adjournment. There will be no adjournment.
On any other.
Because on that day, because it will be trial only, it
My
will
lord.
take time.
My
So
lord.
election petition and then and the fixed matter only.
My lord.
Okay.
On 5th, no,
Ob-
lordship.
obliged,
Fixed
my
matter and the motion, if any.
Okay.
Okay.
Item number 23.
May it please your lordship, my lord. Am I audible, my lord?
Yes, yes.
Yes, my lord, this is an IA which we have filed 320 of 2025 in the contempt application. Contempt application, because the order was passed by this court. We are the landowners, and the notification issued by the state for acquiring my lord, for the purpose of requiring agency was the NHPC for a Dibang multi-purpose project, my lord. Accordingly, initially an award was passed.
Just a minute. This is, we are in IA.
IA 320 of 2025, my lord.
Okay, this is application for?
My lord, for releasing of the payment, my lord. Kindly see, my lord, the prayer portion.
Release of-
Yes, kindly
Okay.
see page 11. Kindly see, my lord. Kindly see page 11. Kindly see
Yes.
page 11. Pray that your lordship will be graciously pleased to admit the directly contempt number 1, 6, and 7. Respond authority to deposit the award cover within a period of 2 weeks for appropriate disbursement to the applicant. So this is the, my lord, we have filed an IA in respect of a contempt. Now in the contempt, my lord, application, they have filed an IA 304 of 2025, which is also there, my lord. Kindly see, which has been fixed on 16/12. The last was 16/12/2025. It is fixed on 23rd of January 2026. If your lordship will
These
kindly see the
IAs
order
are
of,
in contempt petition only?
yes, contempt. So now there are two applications before this court. One is IA 305 of 304 of 2025, which has been filed by the NSPC, challenging the maintainability of the contempt application. Contempt petition, we have filed a reply, and the matter is fixed on 23rd of January 2026, my lord.
Okay.
Right,
Yes.
Milo? Now, we have filed an IA 320 of 2025. Now, in this IA, we have prayed, I have shown before this court to the applicant, that is contender number 1, 6, and 7, NHPC, my lord, for the depositing the award compensation. If you see para 9 of this application, kindly see para 9, my lord, at page 9 of this IA 320, my lord. See para 9. May I read para 9, my lord? That again the said paragraph 20 mentioned by the contender number 1, 6, and 7 in IA C 304 of 2025. That is the IA, my lord, 304. Applicant herein filed two representation dated 8/12/2025 seeking immediate compliance of the order dated 10/2/2025 passed in WPC 242 2020 and WPC 230 of 2024 and release of 48 crores 45 so and so as compensation. Furthermore, since already 4 months has elapsed from the date of passing of the award dated 1/8/2025, there cannot be any further reasonable period of time to be granted to the NHPC authorities other than the release of the compensation amount or rupees 48 crores 45 lakhs and 537 only. Now please see para 10. Please see para 10.
Yes.
That the applicant beg to state that from perusal of the contention and annexure herein above, it is clear that NSPC authorities, though through the contempt, now it will be true, Milo, contempt number 1, 6, and 7 are trying to deliberately delaying the release of complaint amount of rupees 48 crores in odd amount, as the contemptor have themselves agreed that they are ready to deposit the same within a reasonable period of time. It is respectfully submitted during the writ proceeding on the basis of the representation made by the parties, the learned single judge was induced to take a particular course of action and accordingly dispose of the writ petition. It is well settled that attempts to manipulate the course of litigation through dishonest or obstructive conduct or to distort the decision of this court would inevitably be tantamount to contempt even without an explicit direction, as such action interfere with the administration of justice, undermine and the respect and authority of judicial rule of law. Contempt jurisdiction is not construed by any formally or rigid approach. The deliberate conduct of parties aimed at frustrating court proceedings or circumventing its eventual decision may amount to contempt. Now, my lord, I will tell one thing before this court, that earlier the judgment of the Supreme Court was contempt means only punishment. Now there are judgments which I will show later on that even in a contempt application, interim order can be passed in a contempt application. Now if you see para 11, kindly see para 11. See, most important para 11. It is respectfully submitted that WPC 242 of 2020 and WPC 230 of 2024 were disposed of by the learned single judge by order dated 10/2/2025, directing the reassessment of the applicant led at Viswanagar as per the Act 2013 within a period of 3 months, which means thereby that a fresh award and payment of compensation ought to have been completed by 10/5/2025. Be that as it may, admittedly the reassessed award has been received by NSPC authorities on 4/8/2025. However, the contender number 1, 6 and 7, while challenging the maintainability of the contempt petition of the applicant in IA 304 AP 2025, have further sought a reasonable time for consideration and scrutiny of the award. Therefore, it appears that the applicants are aware that they are in contempt willful disobedience of the final order and judgment dated 10/2/2025 passed by the learned single judge in the writ petition. It is well settled that beyond the punishment and contempt for willful and deliberate disobedience, the Honorable can take restitutive measures at any stage of the proceeding by issuing appropriate direction. Contemptor cannot be permitted to enjoy the fruits of the contempt by mere suffering the punishment meted out to them. Earlier, your lordship knows that suppose my lord civil court, civil case, a decree can be passed, it can be executed. But contempt, my lord, there is no execution. So Supreme Court heavily has come down with 2-3 judgments, which I don't want to trouble today, my lord. In a contempt application also, or restrictive measure at any stage can be permitted, can be proceeded and can be passed by this honorable court. I will, my lord, place this at the appropriate stage when the hearing takes place. What I pray today, my lord, a notice may be issued in this case, and let the NSPC, my lord, take their instruction, my lord, what they want to say. They can reply also to our IA, my lord.
NSPC. Well, in the contempt case, Mr. Saxena is appearing for petitioner, sorry, respondent number 1. Okay. And I'm appearing for respondent number 6 and 7. Okay. This respondent number 1 NSPC. It says officials of NSPC in their personal capacity. Okay. This respondent number 1, 6 and 7, they have filed a combined application. That is IA 304 of 2025 challenging the maintainability of that is yet to be disposed. Yes. Contempt petition qua these respondents, my lord. Until and unless that maintainability is decided, my lord, the issue whether to deposit the money or not cannot be decided, my lord. Because in my humble submission, my lord, in the maintainability, have you yes, they have filed, they have filed affidavit. They have filed
affidavit. We have given a reply. Okay. Where, my lord, I will tell one thing. That's why I said to your lordship, in a contempt application, maintainability will be decided. That's true, my lord. Maintainability has to be decided. But in a contempt application, in any time, any stage of the proceeding, a restrictive order can be passed. That your lordship, let them take time. If they say that no, that we want to file a reply saying this is not maintainable, let them file an application before the court. They reply that this is not maintainable. The maintainability has to be heard first. Let them file a reply. Let them file a reply. I will deal that, my lord.
You obtain instruction or file in our
my lord, they have to file. They have to file a reply.
File
so that
objection.
tomorrow,
Since, whatever may be, but then since they have already filed, you file an objection. My lord, in our IA, there's a judicial order that is 16/12/2025, by which the main contempt petition and our IA has been fixed on 23rd of January 2026. My lord. Yes, therefore, I pray that this IA may also be listed on 23rd
yes,
of
no
January
problem.
2026.
My lord, 23rd of January 2025,
Meantime,
it can be
will
tagged.
take instruction.
Meantime, they will file a reply in this if they want.
My lord. Okay.
That will do.
This is IA 320. Okay. Planning Senior Counsel, assisted by Mr. Payang. This is an application. By filing this application, the applicant petitioner is seeking direction to the respondent
1, 6, and 7.
1, 6, and 7 to deposit and release the awarded compensation of rupees 48 lakhs 45,000.
No, my lord.
Sorry, 48 crore 45 lakhs 537 rupees. Huh? Seek the respondent number so and so to deposit the awarded compensation of rupees so and so. Okay. Issue notice. Since Mr. Both of them, huh? Mr. Who comes first?
Yes, Saxena.
R1. Saxena for Saxena appear and accept the notice on behalf of respondent number 1 and Mr. Thungon, huh? RL Thungon for respondent number
6 and
6 and 7. You have received the copy also?
No.
Okay. No. And Miss Sangeeta for on behalf of Mr. S.W. Nanasina, government advocate for respondent state respondent number
2 and 3.
Two and 3. Okay, no formal notice needed required to be issued. Stop. Huh? Extra copy not required. Is there any private respondent also?
My lord,
All are in official capacity, personal capacity.
Okay. The applicant shall take steps upon the rest of the respondent.
Also 4 and 5 are there where they have been struck out.
no, not
Okay,
required, my
already
lord.
struck out. Okay, then all okay.
All, yes.
Then in that case,
My lord, government has complied.
and sought for time and appear no formal notice required to be issued to them. However, they sought for time to file objection.
Yes.
Okay, stop. Huh? On the request of the parties, and the list is matter on
23rd.
23rd
23rd.
of January
January 2026. my lord.
January along with the
2026.
along with the IA number 304. Okay.
My lord,
Okay.
this only humble request, my lord, let this matter come on admission column, my lord. Because they will file
So-
a reply. In the meantime, they can serve the copy to us also. Admission column, my lord.
Okay, in admin, list and so for admission.
Yes,
Okay.
my lord. I am deeply obliged, my lord.
Yes.
It is over.
Over. Okay.